Tracy Shaw for wrongful eviction and an assault.
Court come to order. All rise.
Be seated, please.
Kevin.
Case 2097, Duran versus Shaw.
Thank you.
You're welcome.
Ms. Duran, the defendant is the property manager at a place where you used to live.
Yes.
And you are suing her for evicting you from that place. You want a whole bunch of money. You're suing her for $10,000 for your moving expenses, for assault, for emotional distress because you had to move. Ms. Shaw says that your behavior caused you to be evicted. You violated the rules, and that's why you were served notice of eviction. So first, let me know when you started living at the property that is managed by the defendant.
In 2018.
Did you have a lease?
Yes, I did.
Do you have a copy of that lease with you?
Yes, I do.
I'd like to take a look at it.
Melissa produces a document, then hands it to Kevin. He brings it to Judy, who reviews it.
Okay, so this initial lease was August of 2019, and it terminated on July 31st, 2020. It provided for 3 people to live in the apartment. Okay, and was the lease renewed?
Nope.
Okay, and so then you became a month-to-month tenant?
Yes.
And that was in February of 2020?
They also increased the rent.
That's okay, they're allowed to do that. That's a business.
No, I know.
They're allowed to do that. When your lease was extended on a month-to-month basis after February of 2020, would you tell me if the same people lived in the apartment as were on the original lease?
No.
So more people moved in?
Yes.
Who?
That would be my sisters and my mother.
Sisters?
Yes.
2 sisters?
Yes.
And when did they move in?
Maybe about, maybe 2020, maybe? Couldn't really be positive.
So that would have been in violation of your original lease?
Yes.
And it was an apartment that you were
Yes.
renting? And the apartment complex has a pool?
Yes, it does.
And the incident around, circumstances surrounding this eviction that was served on you, that happened in what month and year?
It was in June of this year.
How long, Ms. Shaw, have you been the property manager?
Since the end of November of last year.
November of 2021?
Yes.
And in November of 2021, did you know that there were additional people living in the house?
Yes.
And didn't tell her that they had to vacate, that it was in violation of the terms of her underlying lease?
I had that morning, actually, when the confrontation happened.
No, I'm talking about, pay attention. My question was, did you register any complaint with the plaintiff about the additional people living there? Be very careful that you tell me the truth, because I know that you think you may know where I'm going, but you don't. Did you make any complaint to her November, December, January, February, March, April, or May? The answer is either yes or no about the other people living in the house.
No.
So I guess I'm going to start with you, because an incident occurred that resulted in her being evicted, that you're serving her with a notice of eviction.
Right.
Tell me when that took place, because I have to know what your reason was. That's a fair statement.
Yes.
Right.
Okay.
So in June 22, like I said, that morning I had served on
What
that
morning?
June 21st or something, I believe.
What kind of letter were you serving on her?
I just gave them, mine is, it's just a complaint notice, you know, saying that.
Do you have a copy of that?
I may.
Do you know what she's talking about?
Yes, I have a copy.
I'd like to see it.
There you go.
Melissa produces a document. Kevin collects it, then brings it to Judy, who reviews it.
Okay, well, this is a letter that says you and your company were eating and drinking in the pool area. Even after I told them to stop, that it wasn't allowed, they did not stop. And there is absolutely no eating or drinking in the pool area. Okay, so that's the letter she served to you, and that was on June 21st.
That's the letter she
Now, who was eating and drinking in the pool?
That would be my sister.
That wasn't just your sister.
No, it was her and her friend.
No, just a second. Let's get it together. So your sister, who wasn't supposed to be there, but they sort of let that skate.
Oh.
Who
Well,
wasn't supposed to be there.
Okay.
Okay, so your sister and who else?
That would be my sister, her boyfriend, and 2 of her friends, or 3 of her friends, I think.
Had they ever been to the pool before?
My sister has, but not her friends.
So the person who wasn't supposed to be living with you, that's your sister,
Yes.
invited her boyfriend and 3 other friends to the pool.
She called and asked if it was okay first.
She asked you.
Yes.
And you said fine.
Yes.
You didn't call the manager.
No.
Okay. And you are aware that there's no eating and drinking in the pool.
That's not what it says on my lease.
Is that what it says at the pool?
Nope.
Does it say anywhere in the house rules?
Nope.
Nope, it's not an answer.
Oh, I'm sorry.
The answer is
No,
no.
no, ma'am, it is not.
No. Now, when you've been living there for a long time, do you use the pool?
Yes, I do.
Ever had any trouble in the time from November of last year? Ever had any complaint?
Nope.
Nope is
No,
not an
sorry,
answer.
sorry,
No
I'm
is
sorry.
the answer. No,
Yeah,
no
okay,
complaint.
no, sorry.
Okay. And did you discuss with your sister and her friends that there were any rules that she had to abide by?
No, I did not, because I was not home yet.
Stand up.
Melissa's sister rises.
First name is?
Aaliyah.
You were their boyfriend and 3 girlfriends. Any children?
No.
You know this lady?
Yes.
What happened when she came to tell you that there was no eating or drinking at the pool?
So we were standing.
Just what happened when she told
She
you?
came screaming at us, telling us that we needed to get the food out and that we needed to go.
Get the food out. What kind of food had you
It was
brought
just
in?
pizza and like a soda and water.
So it wasn't a piece of fruit. You were having a meal there, pizza
Yes.
and food. Had you ever seen your sister bring food into the pool area?
Snacks, yeah.
Yeah. I'm not talking about snacks. Did she ever bring food into the pool area?
No.
What prompted you to order food into the pool area?
It was a hot day and we were hungry and I'm not sure.
You asked your sister if it was okay if you and your friends came.
Yes.
Since you never saw anybody, because usually there are signs posted
Yeah.
around a pool. I've lived in enough places to know, and the pool signs usually say no jumping
Yeah.
in the pool, no food or drink around the pool, right?
Yes.
Most pools say that.
Yes.
Did this pool say that?
It just said, like you said, no jumping in the pool, no diving, to come into the pool, but it never said nothing about food, drinks, nothing like that.
Really?
Yes.
Okay, so now you please establish to me, Miss Shaw, that there was notice that there was no food and drink at the pool.
Their pool addendum,
May I see?
Tracy hands a document to Kevin, who brings it to Judy.
and then also no guest addendum.
Just a second.
It's all part of their.
Hold on. You're Melissa Duran,
Yes, I am.
and that's your signature?
Yes.
Yes. The pool is reserved exclusively for the use of residents of the building. That's what it says.
Okay.
That's what you signed. No diving in the pool area, no intoxicated persons. Okay, I just want you to show me here, first of all, the only thing that they are violating is that pool is reserved exclusively for the residents of the building. That's in here, but I don't see anything about food.
The new pool addendum wasn't part of their contract. So when we put out the new one, it was for more updated tenants, but we didn't
Just a
serve
second.
them on the
Hers-
food, we served them on the guests.
Is what you're saying to me. The only thing that she signed is this, and there is no sign around the pool that says no eating or drinking.
There is a sign by the pool.
Do you have a copy
I
of it?
don't have a copy of that.
Why not?
Caption, coming up.
I texted her that I was sorry that they had food in the pool, and I did not know that.
So that you knew they weren't supposed to have food in the pool.
Yeah, but I didn't know they bring it. The thing.
Just a second. That's not what I asked you.
A courthouse. The Judy Justice logo appears. In the courtroom, Melissa and Tracy.
Melissa Duran claims her former property manager, Tracy Shaw, owes for a wrongful eviction and an assault.
Okay, go ahead.
Because she had moved in prior to them changing the pool addendum, I posted the new pool addendum on all of the doors. And I have actually text messages of Melissa asking me, can we, the no floaties? And I said, well, of course,
May I?
For
Oh.
children and whatnot, but not big floaties.
Okay.
So she was acknowledging the pool addendum that I had.
That I'll see. Now, she's going to show me your text messages to her.
Yes.
So you received the revised pool rules.
Yes.
And did the new pool rules say anything about guests?
No, it did not.
So if it said nothing about guests, you originally said that the pool is specifically reserved for residents of the complex.
Yes.
And according to you, the new pool rules, do they talk about having floaties in the pool?
Yes, it did.
Did it talk about having guests at the pool?
Yeah, actually it did.
And what did it say?
There was no problem, just like on the original lease. It was
No.
fine to have guests in the pool.
No, that's not what this says. This says that the pool is reserved for residents of the building only.
Well, we were already told before that it was fine to have guests.
This is the contract that you signed.
Yes, I
Okay?
understand.
So this is the first one that you signed, this one. And absent anything else, this says no guests at the pool. This says residents only.
Okay.
You say that it was the new rules allow you to have guests, or were they silent?
There was nothing on there saying that you cannot have guests. It was mainly just saying that you cannot have floaties, you cannot jump or run into the pool.
Just a second. Did it say anything about food?
No.
Is there a new sign posted around the pool that talks about food?
No, it does
All I
not.
want to see is, Miss Shaw,
Right.
something in the new rules that talks about food. And I'm getting very bored with this. Now, when Miss Shaw came over and told you you couldn't have food, you had to get rid of the food, about what time was that?
Probably like 5, 6. I'm not exactly too sure.
And when had this food and stuff arrived? Was it?
We brought it. We were coming in with the food. We walked in with the food. I'm pretty sure
Just a
she's seen
second.
this.
So you and your group, 5 people, walked in with dinner
Yes.
to the pool area. And did the dinner include any alcoholic beverages
No.
like beer?
Nope.
What kind of drinks were there?
It was Pepsi. It was soda.
And what happened when Miss Shaw came over and told you you weren't allowed to have the food at the pool?
She came very aggressively.
Okay, she came aggressively and she said you're not
stormed
allowed.
out and screamed, get the food out, and you guys need to leave.
And so what did you do?
I told her, okay, I'd get the food out, and I made a call to my sister to come help me with the food. And as we were packaging
Where was your
it-
sister?
She was upstairs.
So when you came out with the food, you came out of the apartment.
No, we had just gotten there. We were coming from another pool area that wasn't
What other
open.
pool area?
My boyfriend's friend. We were going to swim at his pool, but it wasn't available because there was too many people there.
Were you at your boyfriend's house during the day?
No, I was at school, and they were all at work, so we all just met up after everything.
Okay, so you were asked by Miss Shaw to get the food out, and then you called your sister.
Yes, and I told her.
And then what happened?
And I told her if she could come get the food while we swam, or if not, that we
Why
were going to
didn't
leave.
you just get out?
Well, because I was trying to help, because we were splitting the check through the money, so we're splitting the pizza, who's getting what, and all of that. And before we even could leave, she stormed out again, screaming, saying, you guys are getting a notice, you guys are getting a notice, and running up the stairs to her, because she was coming out. And she was like, hey, what's going on? And then she was like, you guys are getting a notice. I'm tired of everybody not listening and coming to me with your problems. And then my sister was like, whoa, hey, relax. I'm coming to get the food. And then she threw the paper and my sister backed up
Okay,
'cause she,
so what,
went
so the
aggressive.
letter, she gave your sister the letter.
It was a notice.
She gave you the paper that said, this is a complaint. There are people in the pool who are eating, drinking. They don't belong here. They're not, whatever. She said, here's your notice.
Yes.
Okay, and that was on the 21st of June. Then what happened?
Well, after she threw the paper at me, she turned back around, still yelling, and she stomped down the stairs, and I'm trying to tell her, you didn't give me time to come and get the food. And she ran back in her apartment and slammed her door.
And she went back to her apartment, and you went where?
Back into my house.
Okay, you went back into your house. And what did you do when you went back into your house?
When I got back there, I texted her, telling her that I was sorry that they had food in the pool, and I did not know that because I did not know at the time.
Just a second. So, Ms. Duran, let's cut to the chase, so that you knew they weren't supposed to have food in the pool, only snacks.
Yeah, but I didn't know they bring it, the thing.
Just a second. That's not what I asked you.
Okay, I'm sorry.
You knew that there was no food in the pool, only water and snacks.
Okay, yes.
So you knew that.
Okay, yes.
Okay. Now, if you know that, and you have given, I'm just telling you what the law is. If you know that there is a rule, and you don't convey that, that's your problem, okay?
Okay.
All right, so that's June 21st, when guests that you agreed to have in the pool, you didn't know that there was food there. You knew that there wasn't supposed to be food there. That knowledge is imparted to your guests. That's a legal assumption. I want to know what happened after June 21st. When were you served with a 3-day notice to quit?
I believe it was on the 24th.
I'd like to see it.
Okay. I have 3 of the same. They sent me 3 of them.
I just have to see one. Did the attorney, who you say you gave by a cash app, return any of the money? Okay, well, you served this 3-day notice to quit, Ms. Shaw, and in it, you are alleging threatens to commit a crime. So I assume that the person, it talks about a statement, threatens to commit a crime. I assume that the threat was directed to you. Yes. In any event, you were given a 3-day notice to quit, but actually you managed to get that extended to 30 days.
Yes.
And one of the things that you had to do was to hire an attorney.
Yes.
And when you hired an attorney, did you hire an attorney and pay a retainer?
Oh, yes, I did.
Okay. I'd like to see proof of what you paid the attorney.
I don't think I bring the one that pertained to the lawyer. What I do have is him finding out what the criminal act was.
No. You're a month-to-month tenant.
Yes.
Landlord has a right to give you a 30-day notice and say you have to quit the premises. You have no legal right to be there. My only question is you were not given 30 days notice. You were given a 3-day notice, and I'm not actually convinced that there was a basis to give you a 3-day notice.
Caption coming up.
If I called him, would he tell me that you paid him
Yes.
$1,200?
Yes, he would. Though I still owe him $250.
So you paid him $950.
Okay, okay.
What do you mean, okay?
A courthouse. The Judy Justice logo appears. In the courtroom, Melissa and Tracy.
Melissa Duran has accused her former property manager, Tracy Shaw, of wrongfully evicting her. Tracy claims Melissa was violating apartment rules.
Now, if you got 30 days, and the reason you got 30 days is because you retained an attorney, I'm prepared to look to see how much you paid the attorney, because that's an expense that you have that you wouldn't have had but for the 3-day notice to quit. They're entitled to tell you to leave. I mean,
Yeah.
You're there with too many people living in the apartment. They've already had a kerfuffle because you allowed your sister and her boyfriend and friends to come to the pool. They were told no food. They ignored them. But I don't think any of that rises to the level of grounds to give you a 3-day notice to quit. I think that if they want to tell you that you have to be out in 30 days, that's reasonable, but they didn't. They gave you a 3-day notice forcing you to hire an attorney. I'm prepared to give you the attorney's fees if you prove to me that you paid an attorney.
I do have proof of that, but I do not have it with me.
Okay. And how much did you pay him? That's an easy thing for me to verify.
I believe it was $1,200.
I want you to think about it
No,
carefully.
it was $1,200 because he had lowered it. He lowered it from $1,400 to $1,200.
And you paid him by check or cash?
I paid him in Cash App is the only way I could.
Did he go to court with you?
We haven't, this is the first court we have been to.
So how did he get you 30 days?
Because I got the 3-day notice and it kept saying I committed a criminal act.
Okay,
So that was the reason why I obtained the lawyer, so he can find out what the criminal act was.
And just by phone calls, he got them to extend it to 30 days. So
Yes.
you were never in, and you left after the 30 days.
I left before the 30, I left on August 1st.
Okay, and where did you go?
I had to move all the way to Atwater, California.
Is that where you live now?
Yes, it is.
And who lives with you?
My husband and my young son, that's it, just the 3 of us. We moved into a smaller, more expensive place.
Okay, and you left your sisters
And my mother,
and your mother.
they are somewhere completely different.
Okay, what do you,
This is in their lease about disturbances and threats.
listen, I've already made a determination that the 3-day notice should have been a 30-day notice to leave. I don't think that anything that I've heard today rises to the level of giving people who've been in the apartment as long as they had, especially over pizza, requires a 3-day notice. So the only question that I'm entertaining on behalf of the plaintiff and the only monetary award that I'm going to contemplate are attorney's fees. Did the attorney, who you say you gave by a Cash App, return any of the money since he never had to go to court for you?
No, he did not.
Just a second. If I called him right now, would he tell me that you paid him
Yes.
$1,200?
Yes, he would. Yes, he would. Though what I was going to tell you is that I did not have enough to pay him completely. I still owe him $250.
So you didn't pay him. So you paid him $950.
Okay, okay. I'm sorry.
What do you mean,
I
okay?
didn't. No, I mean, I'm sorry, I didn't.
So you paid him $950.
Yes.
I'm awarding you $950, which are your attorney's fees, for the reason that, I'm speaking, for the reasons that I've stated, because they have an absolute right to give you a 30-day notice. tell you to leave, and there was a basis for it, actually. And you know, there was a basis for saying your guests, which is you, are not abiding by the rules. You're a month-to-month tenant. Right now, we do not intend to keep you as a tenant. We're giving you 30 days notice to find another place. I think that would have been absolutely a problem. Speaking would have been absolutely appropriate. I think a 3-day notice to quit was inappropriate given the level of infraction. So I'm awarding you the counsel fees because that's what it took to get you your 30 days. This case is over. Thank you very much.
This court is adjourned.
Tracy.
I'm disappointed in the decision.
Her actions of her aggression, throwing something in my face, that was a little bit excessive.
I don't feel that I got to say more of the story that continued to happen.
Her actions caused me to get evicted in 3 days.
They have bad character, and so I don't think that I owe them anything.
I mean, I didn't think anything like would come to this, you know.
I'm just glad they're gone.
I'm happy to be out because I just really wanted her to be held responsible for what she did.
Sarah and Judy.
So a trend I've seen a lot here is plaintiffs suing for wrongful eviction when they're a month-to-month tenant. And from what I've learned in landlord-tenant law in New York, I know it varies a lot from state to state, is the landlord only has to give you as much notice as your term, which if you're a month-to-month tenant would be 30 days. So people have to really understand the legalese of their contract and of their lease, because if you feel like you're being wrongfully evicted as a month-to-month tenant, that's a different standard than if you have a standard year-long written lease.
Well, that's sort of the reason. I didn't think that the one instance that was raised was sufficient.
For the balance of an RV and an assault.
Court come to order. All rise.
Have a seat, please.
Kevin approaches Judge Judy.
Case 2096, Martinez versus Archuleta.
Thank you.
You're welcome.
Judy turns to Erica.
Well, each of you are suing each other for the hefty sum of $10,000. Ms. Martinez, you say you were like a cousin to one of these defendants. Which one?
Tina.
That would be you.
That'd be me.
And your name is?
Felicia Archuleta.
You live together.
Yes.
Are you married?
Yes.
It is your claim that Tina purchased from you an old RV for $1,000, that she currently has possession of the RV, that she has not paid for the RV, and that when you went to their home to collect the money for the RV, that one of them assaulted you.
Both of them.
The defendants say that the original purchase price, which was $1,000, was reduced because the RV was not running. They paid you the $200. Did you give her the $200?
I did.
You did, and that was the day that you took the RV.
No.
When?
That wasn't the day that I took it. So what happened?
No. You took the RV. When did you give her the $200?
This was after I already had it.
Did you ever get $200 from the defendants?
No, I didn't. I received $160 from Tina.
Okay, so let's get back to the RV. How long did you have the RV? And it was just sitting on your property, is that right?
Right.
How long have you had it?
I've had the RV for about 6 years.
What did you do with it? Did you travel with it?
I lived in it for about 2 months, and then I parked it. And
So it was running?
yes.
But at the time you wanted to get rid of it, it wasn't running.
No.
Did you know what was wrong with it?
Yes, the fuel pump was going bad on it, so we had to replace that.
But it didn't start. They had to have it towed.
Right.
Tina towed it
Right.
back to their property.
Yes, they did.
Okay, so when they took it, the agreement was that they were to pay you how much?
$1,000.
And you acknowledged that you were supposed to pay $1,000.
Yes.
Did you get the title at that time?
Not at that time.
You did not.
No.
Is that correct? At the time that they took the RV and had it towed, they gave you no money.
They gave me no
money. Subsequently, they gave you $160.
Correct.
According to you. And tell me under what circumstances they gave you the $160. Tina did.
I went over to their house and they gave me the money in hand.
Okay, and what did you give them?
Well, they had the RV given, the title given to them the day that they took the RV.
And then $160. Did she ever give you any other money?
No.
Now, when did you go over, according to you, to the property to get the rest of the money? And tell me what happened. What date?
It was August 27th. in the evening, I called Tina and told her I was on my way. I went over to her property and
You drove?
I drove my car to her property, and Felicia was outside loading the car.
That's Felicia.
Correct.
That's you.
And so I asked her, where is Tina? She says she is inside. I said, well, can you call her? So she called Tina on her phone. So Tina came out and she comes up to me and says, what's up? And I said, I'm here to get my money. And Tina tells me, no, you're not getting nothing. I told you you're going to get it when I have it. I said, no, that is not the deal. I want all my money or I'm taking the RV. Now, I have text messages that show that about the RV, about her saying, well, if it's going to be such a problem, you come and pick up the RV and your title. You know, I'm coming to have it picked up tonight. You need to make sure that, you know, not to touch it. And I'm going
Who
to
was living in the RV at the time?
I had my friends in there that would help me try to get it started.
So friends of yours were living
Yeah.
in the RV. Okay.
And she told
Go
me.
ahead.
Okay, and so I told her that I was going to throw them out because she has not paid me for my RV. And then in the text, she also replies that, well, if I wanted to be grimy, I got the title and I could go ahead and keep it. And I do have proof of that.
I would like to see those texts.
Here's the proof. Here you go.
Erica hands documents to Kevin.
There's some more. Those ones.
He brings them to Judy, who reviews them.
Well, you acknowledge in the text back and forth that you owe her $800.
Yeah, I never said I didn't. The thing is,
Okay.
Can I tell
Just
you one
say-
thing?
All I'm asking is you acknowledge that you owe her $800. Okay.
Caption, coming up.
I told Tina I'm done with it all. I'm going to make sure that I have someone pick up the RV tonight. And she got upset, screamed, no, you're not. It's a done deal. No, it's not. And I said, I'm getting my RV tonight.
Later,
You chose not to do this shower?
Well, it's not that I didn't choose not to do it. It's she went to Twitter and threatened to beat butt, and I'm not doing business if you want to fight me.
A courthouse. The Judy Justice logo appears. In the courtroom, Erica, Tina, and Felicia.
Erica Martinez claims her cousin, Tina Archuleta, and her wife, Felicia Archuleta, owe for the balance of an RV. Tina and Felicia are countersuing for slander and an assault.
Okay, so I have $800 balance for the RV. Now, you want to tell me about this alleged assault, which, according to you, is worth another $9,000?
Well, yes. Well, as I was speaking with Tina about it after that, me and her were going back and forth. And we were yelling at each other, and then her wife got involved, and I told her, you need to stay out of it. And then I told Tina, I'm done with it all. You know, I'm going back. I'm going to make sure that I have someone pick up the RV tonight. And she got upset, screamed, no, you're not. It's a done deal. No, it's not. You're not doing this. And I said, yes, I am. I'm getting my RV tonight. And then I turned around, went into my car. Felicia says, you ain't getting spit on me from the passenger side. And Tina runs up and punched me in my face, and my glasses flew this way. And that's when I told her, that's it, she's in trouble now. And so that's
Do you have
when
a police report on that?
I do.
On photographs? Do you have any medical record?
I do got the medical records. They're right here.
Erica produces documents, then hands them to Kevin, who brings them to Judy. She reviews them.
Okay, this is standard fare. It doesn't give me...
It shows that I did go to the doctors 2 days after because I was having migraines. And I was showing them that.
That's why I'm not understanding it, because it doesn't make sense. Okay. Do you have photographs of your alleged injury to your face?
No, I have the police reports, but it takes 15 days for them to
Just
know
a second. All I'm asking you is, you don't have medical records of the day of this injury. You had a headache. 2 days later, you went to the hospital. So this is useless to me. You don't have photos of your injury, and you don't have a police report. Is that what you're telling me?
I do have the police number for it, but I don't have the report on me, no.
No. Okay. So far, they owe you $800. Now you have a counterclaim, because you acknowledge you owed her $800. You have a counterclaim for harassment, slander, and assault. Who are you alleging the plaintiff assaulted?
Can I
Who are
go
you?
back to something?
No. Who are you alleging the plaintiff assaulted? That would be you. That's Felicia. How did the plaintiff assault you?
She ran me over.
She tried to run it over.
Tried to run me over.
Well, there's a difference between running you over and trying to run you over. Did she run you over, or did she attempt to run you over?
She attempted to run me over.
Okay, so that at best would be an attempted assault.
Yes.
So you suffered no injuries?
No.
Okay. Do you have any police report?
I do, Your Honor.
Indicating that you told the police on that date that she attempted to run you over?
This is the one where it says where she tried to run my wife over.
Okay, I'd like to see it, please.
This is the original.
No, I don't. That's all I want.
Tina hands a document to Kevin, who brings it to Judy. She reviews it.
Okay, so it says I told her to start the truck up and move her car because I was leaving and she was behind us, still arguing. So she put it in gear and tried to hit my wife. Is that what you're talking about? Mm-hmm. Okay. Did you suffer any injuries?
No, Your Honor, I did not.
Okay. So this case is a very simple one.
And then, Your Honor,
Tina, the case is a very simple one. You owe her $800 for the balance of the RV, which you acknowledge in your text. But the only other part that you have is for slander. Now, you say that in your cross complaint, the plaintiff has slandered you. I'd like to see the evidence that you have that she has slandered you. May I see it, please?
I need to show her she wanted the dog.
Tina hands a document to Kevin, who brings it to Judy.
This isn't slander. I mean, she calls you nasty names, but sticks and stones, and she says they wouldn't pay me for my stuff, my RV, and so forth. That's not slander.
Can I say one thing that I need to get out there? Because originally, the first thing before even doing any of this, she wanted a puppy. And that's where all this title and everything came in.
I read that.
She wanted a puppy.
I read that, and then she changed her mind.
Yeah, and that's where we got the title.
I don't care. You owe her $800. You acknowledge in your text messages.
Try to keep the peace.
Listen to me. I don't care. You acknowledge that you owed her $800, the balance of the $1,000 for the RV. She came to try to get it. There was an argument, and it got nasty. You owe her, Tina, the $800 that you agreed to pay her, the balance of the RV. Judgment for the plaintiff. Counterclaims dismissed. We're done.
This court is adjourned.
Yeah, I don't like it. I'm very happy with it. She wanted a dog. That's why she gave me the title.
She had asked me if I wanted a puppy, but she said that she'd make a deal with me and only charged me $1,200, which she changed her words, and it was $1,500, so I did not get the puppy.
I tried to keep the peace and say, oh, okay, I'll pay you after she changed her mind.
She's a good liar.
She's just a liar. I don't care. She needs money more than I do.
I honestly think it's ridiculous. We should never have to come to this.
The shame family. It's all good.
No more family, for sure.
Sarah.
This case was another great example of why it's so important, especially with family and friends, if you're going to sell something of value, to have it in writing. People assume with strangers, oh, of course I should have a writing when I'm selling something. But when it's to a friend or a family member, that gift and loan line are very close together, and a writing proves to this court very easily which one of the two it is. So I think that that's a great takeaway from cases like these.
It is. It's a great takeaway. I've always said that when you apply for a marriage license, usually you just have to show your citizenship, date of birth, but I actually think that a marriage license should include all the property that you claim as separate property.
Yeah.
Wouldn't that be easy? It would do away with probably 30% or 40% of the divorce proceedings that become acrimonious because you sort of lay it out. So I think that really writing is always important because at the time, you're usually happy with each other. At the time that you're contesting that sale, you're not so happy. So if you have a writing or if you have a license, it makes everybody's job and your stress level reduced. And I'm all about reducing my stress level.
Of course.
Case 2150, Thomas Williams versus Gilmore. All parties, please step forward.
Diamond Thomas and Rumby Williams are suing Rumby's former friend, Shamia Gilmore, for a deposit and the costs of a brunch.
Diamond, this is your boyfriend.
Yes.
And you were planning a baby shower?
It was actually a sip and see for her.
What is that?
So it's like family and friends weren't allowed to really come to the hospital, so we decided to have a little event after the baby turned 6 weeks.
Okay, so
for
that was
family.
October 22nd.
Yes.
You hired Miss Gilmore as the caterer of that little event. She quoted you a price of $500 to cater the event, and you gave her a $250 deposit.
Correct.
Then some stuff bothered you a little bit because you, according to what I read, you found some either text messages or whatever between the defendant and boyfriend, which you felt were a little too cozy by her.
Yes.
And you gave her a buzz and you sort of had it out with her. I don't want you to do this anymore, whatever. Anyway, you called her back and said, yes, I want you to do it. She ended up not doing this sip and see. And she finally called you and said, I'm not doing it. I don't like the attitude, I'm not doing it. And you said, fine, give me my $250 back. She said, no. So you're suing her for not only your deposit back, $250, you did hire other people to cater the event.
No, we did it ourselves.
And you want her to pay $1,025 because you said that that's what it cost you over and above $250 plus the rest.
Yes.
Well, that you can't have.
Caption coming up.
An offer and acceptance and a meeting of the minds. That was the contract. That doesn't have to be in writing.
We have a verbal agreement via
Well, that's what
Instagram.
that's what I just said.
So it is in writing.
Who cares?
A courthouse. The Judy Justice logo appears. In the courtroom, Diamond, Rumby, and Shamia.
Diamond Thomas and Rumby Williams claim Rumby's former friend, Shamia Gilmore, owe for a deposit and the cost of a brunch.
Okay, you're going to tell me you chose not to do this shower? You chose not to do it.
Well, it's not that I didn't choose not to do it. It's she went to Twitter and threatened to beat butt, and I'm not doing business if you want to fight me.
Okay.
It doesn't make sense. To be in the
Okay,
same-
well, I don't blame you. If she went to Twitter and said something nasty about you, then I wouldn't do her baby shower, sip and whatever they call it. I wouldn't do it either. Then you have to give her back her $250.
And I bought items for the brunch already. I offered the mimosa bar back and I offered $125 back. She wants the whole thing. If I already spent money out my pocket, there's no way you think I'm finna give you a whole $250. That doesn't make sense.
Well, just a second. Okay, let me see what she wrote about you on Twitter.
And also, Judge.
So what you're saying is you actually made a purchase.
Yes, ma'am.
Okay, you have proof of that purchase that you made?
I have the mimosa bar. I don't have it with me, but I didn't print anything off.
I don't
still
even
have
know
the
what that
mimosa
is.
bar.
What is a mimosa bar?
So it's where you put the mimosa glasses on it's a grass wall, but it has where you hang the cups up at on the wall with the mimosa glass, like the champagne flutes that you put on the wall. And then it has.
Have you used that before? When
No,
you've
well, I
catered?
bought one before, but I still have it brand new.
Just a second. Have you used it before? You're a caterer.
Yes, ma'am.
How many times?
Quite a few.
How many?
You know, 2 hands, maybe 7 or 8 times.
Okay. And you buy a new one each time you use it?
Yes, ma'am. I let them keep it.
Just a second. You let them keep it. Well, now you can keep this one and use it next time.
Okay.
And I would like to say something about the $950 that she owes us. We gave her a deposit of $250, and she is claiming that we had made anything threatening towards her.
No, just a second.
And she canceled on us. And so I feel that we didn't have enough ample time to be able to find another caterer to do our event.
Well, that's too bad.
Can I ask why?
Absolutely, because you're entitled to your money back, but your contract was for her to do a party, which she ended up not doing.
Can we see the contract? Because I don't.
No, you haven't. We
don't have the contract.
Yeah, and
yes, you do. You had an agreement. She was going to do an event for you on October 22nd. You agreed for her to do the event for you on October 22nd, and you gave her a $250 deposit. That's a contract. It's an oral contract. You had an offer. You had an acceptance. That's a contract. An offer and acceptance and a meeting of the minds. She was going to do the event for $500. You paid her $250. That was the contract. That doesn't have to be in writing.
We have a verbal agreement via
That's what
Instagram.
That's what I just said.
So it is in writing.
Who cares?
Well, it was the point that how are we supposed to be compensated for everything that we had to do after she canceled?
Well, you have to grow up. You have a baby.
Yes.
Right?
Yes.
Is this your only baby?
Yes.
Great, you have a baby. You have to grow up. I grew up so much, the old me would have beat out one of you. What is that?
I'm not sure.
Would you show this to the plaintiff? I'm just curious. She's going to give you back your $250 anyway. She chose not to do the event.
Kevin hands a document to Diamond.
What?
I don't know what that is. I'm showing it to you. She gave me to show me something that you wrote.
You want me to read this?
No, I'm
or
just
you want me to
asking.
tell you what it is?
No, I'm just asking you if you were the author of that.
Yes.
And did you write it about?
It was just a general statement. It wasn't about anybody in particular. That's why I didn't
give that back.
Direct it. The name.
We're very, very easy. Your baby nice? You happy with your baby?
Yes.
Very good. Do you have nothing to do with her anymore?
No.
Good. You have a mimosa wall. Use it for another event. Judgment for the plaintiff in the amount of $250. We're done here. Thank you very much.
This court is adjourned.
I don't agree with the judge's decision.
I'm satisfied with the $250 and knowing that Shamia was wrong to keep our deposit after she canceled on us.
It's just a lot of mess. I won't do business with them ever again.
It is what it is. If she felt some type of way, that's on her.
I'm gonna keep on doing what I'm doing.
We just won't ever do business with her again because she is very unprofessional, just like the tweet said.
Judy.
Do you know it's an exciting day when at my age you learn something new?
We learn a lot of new things here.
Learn a lot of new things here. So I've just about mastered the engagement party, the wedding, bar mitzvahs, bat mitzvahs, quinceañeras, christenings, baptisms, baby showers, if I haven't mentioned that, anniversary parties. But this is the first time I ever heard that expression.
For truck damage.
Court come to order. All rise.
Judy.
Have a seat, please.
Kevin approaches.
Hello, Judge. Case 2095, Gonzalez versus Gilbert.
Thank you.
You're welcome.
Judy turns to Bobby.
Mr. Gonzalez.
Yes, ma'am.
You're seeking substantial amount of money to refurbish your car after it was hit by the defendant's car while your car was parked.
Yes, ma'am.
The defendants are seeking the same amount of money because they say that despite the fact that one of them did in fact hit your parked car, it was your fault. That's your defense.
Yes, ma'am.
Okay,
Yes, ma'am.
who was driving?
I was driving.
Okay. Mr. Gilbert, on what date did this incident happen?
February 3rd,
What time?
about 5:30 in the morning.
Who was in the car with you?
Nobody. I was by myself. I was going to pick up my son
You were going to pick up your son from where?
from his mother's house to take him to school.
And where does he go to school that he has to be there at 5:30 in the morning?
He doesn't have to be there at 5:30. I have to leave at 5:30 to get him there by 7.
Do you take him to school every day?
No.
What was different about February 3rd?
His mother, stepfather, and the rest of their family was out of town. They had asked me to take him to school that day.
Just for that one day?
Yep.
Yep is not an answer.
Oh, yes, ma'am.
Yes,
Yes,
is an
Your Honor.
answer. Okay, so it's about 5:30 in the morning, and?
I left my house. It was
Look at me.
raining. It was cold. It's pretty much the same route I take every day, not at that same time. I was approaching a stop sign at an intersection by the plaintiff's house, and I seen, I guess, either a reflection or what I thought were lights headed in my direction, so I swerved. And
Okay, you're still traveling, so you're moving. Does somebody have a diagram of where this happened? There it is. Okay. You were approaching a stop sign.
yeah, I was approaching an intersection.
So right on...
Were you there?
No, ma'am.
Sit down.
Yes, ma'am.
Heather sits.
You were approaching an intersection.
Yeah.
It's a two-way road.
Yeah.
And it looks to me from that, is that an accurate representation?
Yeah, except for there was another vehicle on the other side of the road.
Okay, but it looks to me that you're traveling sort of in the middle of the road.
Yeah, it floods.
Okay, and a car is coming from something. You're not sure what.
Yeah, I wasn't sure what.
You were not sure what.
And I swerved. I
you
just got over to the proper side of the road.
And your car swerved, and when your car swerved, it hit that blue car that's sitting there. That's the plaintiff's car that was sitting in front of his house.
Mm-hmm.
Uh-huh is not
Yes,
an
ma'am.
answer. Yes, okay. Now, do you want to tell me what you did next?
I went through the intersection, turned around to follow what I thought might have been a vehicle headed my direction. And when I didn't see a vehicle, I took my vehicle home. I parked it. I got my insurance information, my driver's license, and I walked back to his house to trade insurance information with him.
Okay. You have a video of this incident?
Yes, ma'am.
From where?
From my surveillance cameras.
Is it set up for me to watch it
Yes, ma'am.
here?
Yes, it is.
Okay, I'm ready. That's your car, sir?
Yes.
Okay, let's see that again.
Footage of a collision.
Notice how the truck is covered?
Okay, so you hit the plaintiff's car hard enough to push it up on the curb?
Speed limit is 30 miles an hour.
I've just asked you a question.
Yes, ma'am.
It looks as if you hit it hard enough to push it up on the curb.
Yes, I did.
But you told me a moment ago, Mr. Gilbert, and you just piped in that the speed limit there is 30 miles an hour. You said you were slowing down for a stop sign.
I said I was approaching a stop sign.
Well, when you're approaching a stop sign, you don't approach a stop sign at 30 miles an hour, especially if it's in a neighborhood that you've been in. But according to you, you drive that neighborhood regularly.
Yep.
However, not at that time. That's what you said.
Yes, ma'am.
So if you are approaching a stop sign, when I approach a stop sign, and if I know there's a stop sign there, I start applying my brakes a little bit before. Now, I do drive with some people who sort of like to play chicky with a stop sign, you know. Maybe the stop sign is going to move. Maybe it's going to become a welcome mat. So they wait until they get right up to it and put their brakes on. But that's not what you told me you did.
No, ma'am.
Okay. So now I'm going to say, if you were going very slowly, sir, approaching a stop sign, you wouldn't have hit his car with such force that you push him up on the curb. Okay. Your defense is to this action, as I said, that he was parked and he had this car that was covered and it was parked facing the wrong direction, which is totally irrelevant as to was facing the wrong
according to
direction.
Texas state
It
law.
was on. It's covered over, so you don't know which direction it was facing in. Certainly, the light wasn't on it. If you're
I've passed this.
I didn't ask you for anything. You weren't there.
Yes, ma'am.
You weren't there.
Yes, ma'am, but
She lives in the neighborhood. She drives by it every day.
Just a second. What do I need that for? I have a video.
Okay.
I have a video.
Can you see the stop sign in the video? No. You have no idea how close I was.
You just told me you were approaching a stop sign.
Yeah,
Would
there
you
is
read
a
that
stop
back to
sign.
me?
There is a stop sign.
Would you read that back to me? I was approaching a stop sign. Does he say I slowed down? I was approaching a stop sign. I don't remember.
It's about.
I didn't say. I did not
now
say.
you can leave.
I did not say I was slowing down.
Now you can leave.
Heather leaves.
I did not say I was slowing down. I said I was approaching a stop sign.
Okay, that's what I thought. But that's why we have Whitney.
Let's see, he says he was approaching a stop sign at an intersection by the plaintiff's house, and I can see either a reflection or what I see lights headed in my direction, so I swerve.
Now I would like to see that video again one more time. I would like to see if I see something coming towards you. Actually, I don't see another vehicle coming towards you. Is that a truck parked there?
It's a food truck behind it. It's like catty corner to his vehicle. There's a food trailer there that had all of the light, right.
A food truck on the other side of the street.
Yes, ma'am.
A food truck that you could see, but that's parked.
Well, I assume since there was no actual lights coming, I assume maybe that's what light reflected off of.
You don't assume anything. All you know is you saw something that made you swerve.
Yes, ma'am.
Whether it was there or not there. So am I getting the fact that your total defense is based on the fact that his car shouldn't have been parked there?
Yes, ma'am. Or covered.
Yeah, well, but that's a finable offense, Mr. Gilbert. That's a finable offense.
If it doesn't cause an accident.
No, I don't think it caused the accident. You caused the accident.
How did
You
I cause
caused the accident. This is an inert object.
According to my HOA guidelines, that vehicle is supposed to be in his garage. According to Texas state law, it's not supposed to be on the road.
And I'm going to tell you, I absolutely agree with you that that's a finable offense if his car is parked.
So
you're trying to interrupt me.
Okay.
That it's a finable offense. The question is his car being parked illegally the proximate cause of this accident? That's the question. Would that be a fair?
It is.
I didn't ask you a question unless you went to law school.
Huh? No, ma'am,
Unless you went to law school. Am I in the realm? You're closer than that, was Palsgraf versus Long Island Railroad. His car may have been parked in the wrong spot. Yeah. If you had somebody that left a baby carriage with a baby on the street, which is certainly against the law and would be a neglectful act on the part of the parent, and if you happen to swerve up to avoid something and hit that baby carriage, you can't say that baby carriage is the cause of the accident.
No,
You're the
carriage
cause of the
isn't.
accident.
No, the owner of the baby carriage is.
No, you are.
No, they are.
So
how am
what?
I responsible for their baby carriage?
Because your car is moving, sir, and if you're approaching a stop sign, you're not supposed
If
to
the
be going.
vehicle wasn't covered, you
just a
could see
second.
the reflectors that are on it. That's what they're there for.
Reflectors on
Yeah,
what?
reflectors on the truck that's covered. They have headlights, turn signals, everything that's reflective that you could see. There was no reflectors or signals for me to see to know it was there.
You would have hit it whether it was covered or not.
Of course.
Very good. May I please see the...
That's horse. I
Please
wouldn't
see.
have hit it could I seen it.
Kevin, I want to see what he's got as far as work for the car.
Kevin retrieves a document from Bobby, then brings it to Judy.
Okay, so this is clearly a project car, sir.
Yes, ma'am.
Yeah, it's it don't
so
run.
Get him out of here.
Let's go.
He's done. He's done.
Okay.
Thank you, Lord.
Kevin escorts John out.
Oh, that makes my life so much easier.
Bobby grins.
And later today,
You know, you wanted to go. There was no reason why you couldn't. That's why you drive a motorcycle, because you can get into tight places and you can go. But you look like an intelligent young woman.
Thank you, Your Honor.
Don't take chances. That was a chance. It could have been a lot worse.
A woman nods. A courthouse. The Judy Justice logo appears. In the courtroom, Bobby.
Bobby Gonzalez claims his neighbor, John Gilbert, hit his classic pickup truck. John is countersuing for car damage and harassment.
By the way, both the defendant and his wife have a counterclaim. Their counterclaim is for damages to their car and for harassment. Well, since neither one of them can keep control of themselves, the counterclaim is dismissed. I'm looking at this truck, Mr. Gonzalez. When did you purchase it, sir, and from whom?
In October of last year, I purchased it online.
Do you have the bill of sale from when you purchased it?
I don't have the bill of sale, but on the paperwork, I have the post on Facebook on how much I paid for it. It was for $8,000.
Okay.
I also have an appraisal on there as well.
I see the appraisal, but I don't have what it's going to take to fix the spot where he damaged the car. He damaged the car in this whole side end.
Yes.
I mean, he's not going to give you a classic car.
Well, I know.
That's not going to happen.
I know. I know
Okay.
that.
That's not going to happen. And certainly, you do understand that I'm not awarding you anything close, even though they're two obnoxious people, anything close to $10,000. You do understand that, Mr. Gonzalez. You're going to have to get this car fixed right now. I'm looking. Where is a invoice for either the work you had done or an estimate to fix that part of the car that he injured?
I cannot give that to you because
Well, then I don't have it,
the
sir.
vehicle is a classic. It's very hard to find that type of vehicle.
Well, then what you're asking me is to guess, sir.
Well, I can give you the rates as far as how much I'm
You
gonna have.
can't give me anything.
Okay.
You have to take the car in to somebody who deals with classic cars. So this is a 70-year-old truck, and it's certainly beat up. You had it covered for a long time. It shouldn't have been on the street. You do know that. And I assume that since it's not driven, you didn't have it insured.
Well, I took it out for Halloween, just for the kids.
Well, I mean, where do you suggest that I conjure up a figure of $10,000 when you have a car that's a year old that has never been driven, that you take out and it's a Halloween ornament? So let me explain this to you. I have to guess at a figure. I would be prepared to award you $2,000 to fix your car because I did see that it had to be damaged as a result of the damage to the defendant's car. If you feel as if you would fare better in your local small claims court where this case came from, because I have dismissed their counterclaim, I will dismiss your case without prejudice and you can take it back to the lower court. Take your choice.
I'll go ahead and take it from you. I know I'm not going to get anything from them.
Very good. Judgment for the plaintiff in the amount of $2,000. Counterclaims dismissed. Fix your car. Thank you.
This court is adjourned. Well, I didn't agree on the price, but with them kind of people, I'm not going to get my money back. It's time to get it repaired.
I think you have to be a certain kind of person to not take any accountability when you hit a stationary object. I'll admit, I think that it was probably a 90%, 10% split, 10% plaintiff's fault for parking on the street. I looked up the section code in Texas and did find that if you leave a car longer than 5 days on the street, you're in violation of a code. But like you tried to explain to the very hot-headed defendant, that's a finable offense. That doesn't mean you can ram into it with your vehicle and not be at fault. I just don't know how you take zero accountability after hitting a stationary object.
I don't know either, but that's, I think, a problem with a country that's grown up in the last 50 years, that it's never your fault.
Yep.
It's always somebody else. It's the state's fault. It's the city's fault. It's somebody else's fault. And it's sad because I know that there was lots of acrimony between the two of them without it. But they were hotheads. This is the first time you ever saw me send somebody out.
A long time.
Yeah,
long time since I've seen it. Yeah. But when they're clearly not getting the message and they're being hostile, that's not the proper way to come to court.
No.
Especially when you're in the wrong.
All right, but they have to live near each other. I hope that they get it together.
Just keep your fingers crossed.
Yeah.
Case 2067, Garcia versus Taryn. All parties, please step forward.
Amari Garcia is suing fellow motorist April Taryn for damages from a motorcycle accident.
This is a case that's about an automobile-motorcycle collision. Each one of you claims that the other is responsible for the collision. Miss Garcia, you were riding the motorcycle?
Yes, ma'am.
And you were in your car?
Yes.
Okay. And this happened on what date?
March 21st, 2022, around 3 p.m.
In what state?
California.
In the state of California, are you required to have insurance on a motorcycle?
Yes, Your Honor.
Just liability?
Liability if it's paid for in full, correct. Yes, Your Honor.
And were you insured on that date?
Yes, Your Honor.
And you were driving a car?
Yes.
And was your car insured on March 21st, 2022?
Not at the time.
So the answer is no?
No.
Did you have a valid driver's license on March 21st, 2022?
Yes.
From what state?
California.
What kind of car were you driving?
A 2011 Nissan Sentra.
Was it a new car for you, or did you have it for a while?
It's a new car. I purchased it 3 weeks prior to the incident.
And if you bought it 3 weeks before, how come you didn't have liability insurance?
I was looking for insurance, and plus, at the time, I hadn't received my paperwork. It was still in the other person's name at the used car dealership that I bought it from.
Your Honor.
You know you're not supposed to be driving a car, Miss Taryn, without insurance.
Yes, I'm aware of that.
Okay. You wanted to say something?
Yes, Your Honor, thank you. I have proof that April Taryn purchased her vehicle February 8th, 2022. She drove uninsured for 41 days, and it was not from a lot. It was from someone off the street. I have the proof for that.
I'd like to see it.
Yes.
Amari hands a document to Kevin, who brings it to Judy.
For $2,050.
Judy reviews it.
Well, this car that you registered, the selling price was $2,050, according to this.
No, it wasn't. And
well, I'm going to show you vehicle and transfer law. This is 2011 Sentra, and it was signed, but it's LLC. That's his company.
Okay.
So it wasn't off the street, but it said the selling price was $2,000. That's what this says.
I don't have my paperwork in my car.
Want to show this to her?
Kevin brings the document to April.
I just want to get some basic facts first, and then I'm going to go to the incident.
But that's and...
No, the person, the seller.
And you know, I have my paperwork in my car.
Yeah, but you understand that that's
I understand
what
you said because it's right there. Yes.
Okay, we have a diagram. This happened on March 21st, 3 o'clock in the afternoon. You had no insurance, and you were traveling in the bike lane.
No, that is not true. I shared the lane of the car on the right. I would never go into a bike lane. That is disrespectful to the road and riders.
Just a second. Are you allowed to share a lane with a car and a motorcycle?
That is your right, yes.
I know Foothill. Is that where you were?
Yes, Your Honor.
And at a certain time during the day, Foothill becomes very trafficked.
Yes.
And the cars sometimes get stopped because there's a light, right?
Yes, Your Honor.
Go over to there, Miss Garcia, and show me, please.
Amari approaches the diagram of the accident.
Where you were positioned before you say that you were traveling in the same lane as a car.
Your Honor, I was directly behind this car.
Okay.
Directly behind.
You were directly behind that car.
Yes.
And that car was stopped.
They were slowing to a stop.
No, they were stopped because they had to have been stopped because that's why you went around him.
They were slowing to a stop. By the time I got around here, they were stopped. I didn't want to veer into here. I was slowing down. I was around 25 miles per hour. This lane at the time was too close. So I shared this lane on this side.
Miss Garcia, I got it, Miss Garcia. you want me to appreciate the fact that you wanted to get around the stopped car and you wanted to continue to go straight, correct? You weren't turning. You wanted to go straight.
I was going straight, correct.
And so you want me to picture in this tiny mind of mine that instead of going into a perfectly clear bike lane, you inched your way at 25 miles an hour in the same lane as a stopped car.
Yes.
Right.
This diagram.
You know, I find that hard to believe, Ms. Garcia.
Your
I
Honor,
really find that hard to believe. You may be in the right with regard to this, but I find it hard to believe.
The roads are very wide. I have the actual police photo document of that.
I'd like to see it.
Yes, Your Honor.
Amari returns to the plaintiff's table, then produces a document and hands it to Kevin.
Right here.
And I'd like to see the police report as well. Is there a police report?
It's attached to this.
Fine.
Kevin brings the document to Judy.
Because as you were traveling straight, the defendant was making a left turn. She was making a left turn because the two cars there were stopped, and those were the only two traffic lanes there. Now, I don't know whether she could see whether it's a motorcycle or a bicycle traveling in the bike lane, but what happened was she was making a left turn. According to this, you went into her passenger side. Is that correct?
Yes, Your Honor.
Caption, coming up.
So where is the motorcycle now?
I no longer have it. The towing company, they sold it.
What are you driving around in now?
1995 Chevy Baville.
Atta girl!
A courthouse. The Judy Justice logo appears. In the courtroom, Amari and April.
Amari Garcia is accusing fellow motorist April Taryn of damaging her motorcycle. April claims Amari was illegally driving in the bike lane.
Judy reviews a document.
Who was in the car with you, Miss Taryn?
My son and his girlfriend.
One of them had an injury.
Yes. My son's girlfriend, she was in the driver's passenger side. And while I was turning into the lane, I just felt a crash and saw glass going into my car, and then she was cut.
Okay, and you had an injury to your knee?
Yes, I have several injuries. And I have photos as well.
You understand, Miss Taryn, that the police interviewed witnesses. The witnesses were in the stopped cars.
Yes.
And at the end of all of their interviewing process, they determined that you were the cause of the collision. That's what it says.
And I don't...
It says that you caused the collision by violating Vehicle and Traffic Law 21-8001, failure to yield when making a left turn. I determined the cause based upon the parties involved and the physical evidence. That's what the police determined. Okay, well, then that's an easy, based upon the police report, because each of you are going to tell two different stories about what happened that day. Police were there, they looked at the physical evidence, they looked at the injuries, they looked at the damage to the roadway, they interviewed independent witnesses, and that was their determination.
I understand, Judge, but the police report had some inconsistencies where, like, she was driving in the bicycle lane, which is against the law. And what I was doing, I was making the left turn, as you know. And these two front cars, which one of them was a witness.
Yes, that car paused to let you make a left turn.
Yes, both lanes. And I was...
No, you said both lanes.
Both lanes paused.
Well, that's what you say.
Yes.
That's what you say. That's not what this says.
See, but they both did. And as I was
But I'm just telling you.
No, I know.
Yeah,
that's what
I'm just telling you. That's not what this is. That's what you say. There was nothing that prevented those two cars from going.
Exactly.
There wasn't a traffic light. There wasn't a stoplight at that spot.
Yes.
And there was heavy traffic.
Yes.
So it's your responsibility to make sure if you're making a left turn that you have to yield to all oncoming traffic. And so the fact that you didn't see her is really not relevant. And as long as you understand that this police report supports Miss Garcia's claim that you caused this accident by making a left turn when you shouldn't have been making a left turn, that's what this says. And that, you know, at the end of the day, it's an accident. That's why it's not called an on purpose. It's called an accident. Neither one of you anticipated it. As far as I'm concerned, Ms. Garcia, you're entitled to be compensated, but I'm going to suggest this to you. If I'm driving a motorcycle, which I would never do, just for me, I think it's wacky. I think there are enough crazy people driving around that I like about 2,000 pounds of steel around me, so that if somebody who is not paying attention and there's an accident, I like to be safe. My first car when I was 17, all my friends were getting these cute little cars, you know, that were convertibles, and my father bought me a 15-year-old blue and white Cadillac sedan. It was so embarrassing to drive around in that car. It was a boat. Oh, come on. Everybody else is getting these cute little Corvettes, even if they're used ones. And my father, who loved me a lot, said to me, sweetheart, if you get into the accident, I want you to come out unscathed. And this ensures that you got a shot if you get into an accident. And I feel better. So I'm just telling you, if you're going to drive a motorcycle, don't take shortcuts. I know this place on Foothill, and I know what happened here. You know, you wanted to go, there was no reason why you couldn't. That's why you drive a motorcycle, because you can get into tight places. But you look like an intelligent young woman.
Thank you, Your Honor.
Don't take chances. That was a chance. It could have been a lot worse. What was the damage to your motorcycle?
I have pictures. Would you like to see them, Your Honor?
I would.
I did look it up. Lane splitting motorcycles is legal in California, based on the California Highway Patrol.
Amari hands photos to Kevin, who brings them to Judy. She reviews them.
Okay, no, I see the pictures. So where is the motorcycle now?
I no longer have it. The towing company, they sold it. They sold it for $70 they claim, and I got hit with collections afterwards. I have the bill for that if you'd like to see that.
How much did you pay for it?
$6,407.
Do you have the bill?
Yes.
I'd like to see it.
For my motorcycle, what I paid for, correct?
Yes, what you paid for it.
Amari hands a document to Kevin, who brings it to Judy. She reviews it.
What are you driving around in now?
A 1995 Chevy Baville.
Atta girl! Atta girl. Okay. I'm giving you the value of the motorcycle.
Thank you, Your Honor.
Which is $6,407. I'm not splitting whose fault this was, actually, but I'm not awarding you any punitive damages for her. She had injuries in her car. You were slightly injured, but both of you seem fine now. I don't think that you were careful enough when you were going straight and around that car that was stopped. But the defendant didn't have insurance, and she was cited by the police for violation of a traffic law. So I'm giving you the cost of your motorcycle.
Thank you, Your Honor.
Judgment for the plaintiff.
This court is adjourned.
So I actually ended up, after the car had made impact with me, the bike went that way. I went up into the air.
It was really frightening.
I hit the ground. I hit on my elbow.
I've never experienced that before.
I was really scared. I thought, like, oh, this is it. My legs are out.
And like I said, I was being cautious, and
thankfully I wasn't.
But it ended up in that kind of situation.
Definitely more safely as far as better gear, and, you know, like she said, don't take a shortcut or anything of that sort.
Sarah.
So I looked up lane splitting, and in California, it's one of the few states that allows it for motorcyclists. It does say inexperienced riders shouldn't attempt it because, like we see, it's very easy to get hit or for someone not to see you if you're splitting between lanes, but it is legal, so she wasn't in the wrong by lane splitting, but I...
For television damage caused during an argument.
Court come to order. All rise.
Judge Judy enters.
Have a seat, everyone.
Kevin approaches.
Case 2144, Paramount versus Morgan.
Thank you.
You're welcome.
Judy turns to Jennifer.
Miss Paramount, you and the defendant had been friends.
Yeah.
Then, according to what I read, there was a falling out, which you will tell me about briefly. Subsequently, and without too much time having passed, you decided to conduct an intervention, a drug intervention, with the defendant.
Yes.
And it is your claim that during that drug intervention, she damaged your television set, and you want her to pay for a new TV. That's what your case is about. The defendant has a cross-complaint. She says she's missing some sort of a speaker. I don't know what that is. And for the emotional distress that she suffered as a result of this intervention. So I have a couple of questions, just preliminarily. How long have you known each other?
Over 20 years.
Friends?
Yes, best friends. Former best friends.
Former best friends. But there came a time, according to your complaint, that there was a falling out. And when was that?
That was in May of this year.
And what was the falling out about?
It was about our mutual friend and...
This gentleman?
Yes.
What about your mutual friend?
He was in the hospital, and we were all taking care of him. And she felt adamant to tell me that I need to do certain things for him. And I was letting her know that if he needs to tell me he needs my help, he can tell me.
Okay, there were several people looking after him while he was in the hospital, taking turns. Is that right?
Yes.
And she was telling you things that you should be doing for him, and you said to her, if he wants me to do something, let him tell me, you don't direct me.
Correct.
Okay, tell me the next thing that happened that brings us to court today.
Well, after that, in May, I blocked her. We didn't speak.
Did you go to visit him?
Oh, yes.
Oh, yes. And did you?
Yes.
So you both did. Okay, so you blocked her in May. Then what's the next thing that happened?
Now we're in September, and this was...
And between May and September, you haven't seen her?
Haven't seen her.
Okay.
And now it's September. It's Labor Day weekend, and our friend Brandon wanted to mend our friendship back together. And it kind of did, because we've been friends for so long. We talked and kind of mended.
Okay.
Okay, so I unblocked her. And then on that Sunday, September 4th, she calls me at 7 o'clock in the morning, and I guess she still felt uneasy about, us not talking for so long, that she demanded an apology from me.
She called you early in the morning demanding an apology for what?
For basically just, I was in the wrong of not listening to her about our friend.
Okay, and then what happened?
So I refused to give her an apology. I said, we can move past it, but I'm not apologizing, which she got upset again and hung up the phone on me. And after that, she basically called a family member of mine.
Not basically.
Sorry.
You say that she placed a call to a family member.
Yes.
Okay, and you can't tell me what that family member told you because that's hearsay. You
Correct.
understand that? Okay, so she called a family member, and that was on September 4th.
Yes.
Okay, a family member called you.
The family member actually...
Did what?
Actually lives with me. So they didn't call me.
Okay, well, you can tell me the relationship.
It's just family.
Okay, family member who lives with you, and?
Yes. So she was calling that family member, asking for...
You can't tell me what any of that was about.
I'm sorry. So after the conversation with the family member told me what she said. I know, I'm not saying the conversation.
Absolutely right.
So I told Brandon what she said, and we thought at the time, let's have an intervention.
Okay, now, so without giving any credibility to any out-of-court statements, I assume by the word intervention, you had a suspicion that the defendant was using drugs or alcohol.
Yes.
Before that, before September 4th, did you have any knowledge of ongoing substance abuse with your best friend?
Yes.
Since when?
For a very long time.
Okay. Did you ever discuss the drug use with her?
Yes.
Well, you can tell me what those discussions were like. What kind of drugs were you afraid she was using?
I prefer not to say.
Well, you can't not say. That's what this is all about. You wanted to have an intervention. You didn't want to have an intervention because she was having caramel-covered popcorn. There was a controlled substance, I assume, that you were afraid she was using.
Yes.
Which was what?
Cocaine.
Have you ever seen her using cocaine?
Yes.
Did you ever use cocaine with her?
Yes.
Between May and September, had you ever used cocaine with her?
No.
So it was before that?
Yes.
His name is Brandon?
Yes.
Had Brandon ever used cocaine with the two of you?
No.
Did you ever see Brandon use cocaine?
No.
Okay. So you, who had used cocaine with her, decided to have an intervention with Brandon?
Yes.
What do you do for a living?
I'm an inbound call agent. I sell tickets.
Okay. And what does Brandon do?
He's disabled.
And who was going to be at this intervention?
It was myself, Brandon, and another mutual friend.
Mutual friend. Now, this mutual friend, whose name I will not have you state, have you ever seen that mutual friend use any sort of controlled substance? Answer the question.
Yes.
Yes. So now you have two people who've used controlled substance, one who has not, to your knowledge, doing an intervention.
Correct.
Okay, and do you know what an intervention is?
Yes.
What is it?
It's basically a meeting of the minds of having a discussion with one person about an issue that...
And who's there?
Who's there?
Yeah.
Oh, I would say trusted people that I would feel that they were...
Sarah, I want you to look up the word intervention and read me the very, very simplistic definition of an intervention.
From the Mayo Clinic, an intervention is a carefully planned process that may be done by family and friends in consultation with a doctor or professional, such as a licensed alcohol and drug counselor, or directed by an intervention professional called an interventionalist.
Okay, so what you don't have is something, I assume, this conversation occurred on September 4th.
Correct.
Was it on that same day that you decided to have an intervention?
Yes.
Okay. So let's start with the word well-planned, not as a result of a conversation that you have with somebody. And it's a well-planned event done in conjunction with very often relatives or close family who have a concern that something is out of control, some abusive behavior that's related to either alcohol or other controlled substances, in conjunction with a licensed professional where everything is synchronized, but managed by a professional. Do you understand?
Yes, this was a bad plan.
There was no plan. It was a plan made because you were annoyed.
Cardi nods. Caption coming up.
Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, but they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
Cardi winces. A courthouse. The Judy Justice logo appears. In the courtroom, Jennifer and Cardi.
Jennifer Paramon claims her former friend, Cardi Moran, broke her television. Cardi is countersuing for emotional distress.
Now, you were annoyed at the conversation, so what you did was not really an intervention. What did you think was going to happen at the end of this intervention? What was supposed to happen to her? According to what I read, you called her, or someone called her, probably your family member called her with regard to these drugs that she wanted to purchase. Is that what happened?
Yes.
And said, I have them, come to the house.
Yes.
Okay, so that's not a giant leap. You have to put that together. So she calls your family member for some cocaine. You arrange for an intervention. Your family member calls her at your request and says, come to the house. So that's what happened.
Yes.
Okay, but she was lured to your apartment.
Yes. Yes, I was.
Yes.
By whom?
By us. By her.
What do you mean by us?
They all said,
myself.
Ship up.
Myself, Brandon, and another
Well,
mutual
who
friend.
called her and said, come over?
Who called her?
Yes.
We were already going out. She was already going out with Brandon.
Just a second. She was already going out with Brandon.
Yes. And she decided to come to where I live to come pick up these drugs. Because when she found out that basically the setup was for her to get her to my house. So I told my family member to tell her that we did have it.
Oh, just a second. That's what I said. So she was lured to your house.
Yes.
Where you were going to do what with her? What happened when you got to your house?
Basically, just talk.
Not basically.
Sorry.
Not basically. You lure somebody to the house. She's come to the house now expecting, let us say, expecting to buy drugs or get drugs. She gets there and realizes that that's not going to happen, that there are other people that that's not going to happen. So tell me what happened when she walked in the house. That's what your case is.
Well, when she walked in the house, I immediately tried to give her a hug, and she was upset.
Now, you immediately tried to give her a hug. What did you say?
I didn't say anything. I just open arms. And she said, no, it's fake, backing away.
It's fake. What's
Yes.
fake?
My hug.
Okay, so she backed away.
Yes.
And?
And it just started off with
No. Somebody had to say something to her. Somebody had to say this is an intervention. Somebody had to say why she was there. She eventually was going to say, where are the drugs? But you have to tell me what happened.
Yes, when she walked,
in, you went to give her a hug, pushed you away. Then what? Come on, this was an intervention.
Yes. So we couldn't even get to the part of this is an intervention.
How could you get to an intervention? You don't know what an intervention is.
Well, we couldn't get to a part of let's talk. She immediately said she was being set up. This is a setup with arguments back and forth.
Well, what were the arguments back and forth?
The back and forth arguments.
She said, I'm being set up. Somebody said to her, this is an intervention.
We didn't get to that part.
Well, what is the setup that she was talking about?
I don't know why she
Well, it
said...
was a setup.
It was a setup. It was a setup.
Yeah, so I want to know what your end game was.
The end game was to have a conversation with her so we can resolve our issues of why does she need an apology from me? We have been friends for so long. Her getting to my house, yes, we did lie and say, yes, there was drugs at my house. But she already knew from how we're all there that there was no drugs. She was upset. She was irate. She was bringing up the argument that we had earlier in the morning.
So this wasn't an intervention for drugs or alcohol?
It was an intervention for drugs and alcohol.
Oh, okay. Then I'm asking you, not what happened, what was your end game?
The end game was to have a conversation with her about how much drugs she was doing because it changed her mood. It made her angry.
Well,
it made
did you have a program for her to go to? Did you have a program to take her to? Had you spoken to a professional? Had you done anything?
No.
Okay. And when she was there, according to you, she was in your house with 3 other people?
Myself and Brandon and another mutual friend.
So with 3 other people,
yes.
So she was there with 3 other adults.
Yes.
And she was lured there under false pretenses.
Yes.
And what she did, according to you, was pick up a chair and throw it at you, or threw it at a television set, breaking the television set.
She didn't throw it at me.
What did she do?
She threw it directly at my television.
Judy shrugs.
Lucky she didn't throw it at you?
I wish she would have.
That's
exactly what she said.
Just a second. You're lucky. You can't do what you did. That's almost like kidnapping. If you're having a serious intervention, you have to sit down, have a working plan, what happened, have the right in your heart, have the right messaging. Your messaging was all wrong. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, and they seek professional help in order to get that person professional help. But they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
It was
you
bad.
Can't do that.
It was bad. It was
very bad.
Yeah.
So you fix your own television set. Your case is dismissed.
But, Your Honor, I have it all on video.
Did she break your TV?
Yes.
I'm going to look at the video. Your case is still going to be dismissed. I believe she broke your TV. Show me the video. I believe it.
And I also have
I believe that you're lucky that's all she did in order to get out of your apartment. Did she ultimately leave your apartment?
Forcefully,
Yes.
I kicked her out.
So forcefully, you tricked her into coming in, and then you kicked her out?
Yes, after breaking my property.
Okay.
Video footage.
Why are you like I squirt the dog? I cannot. I said.
Cardi throws a chair.
Are you serious?
I'm ready. I'm ready.
Why am I being recorded?
Just a second. I don't know why you're being recorded. In any event, as I said, your case is dismissed. Fix your own TV. You have a counterclaim.
Yes.
And your counterclaim, I don't know what this speaker is. What is a speaker?
A speaker, you connect your phone to Bluetooth and you hear music on it.
Okay, so what was it doing at her house?
Shh. We were supposed to be hanging out. So I was supposed to be hanging out with Brandon and another mutual friend. I didn't know we were gonna stay at Jennifer's house.
Okay, I just want to know what you brought the speaker?
Yeah, a speaker.
And you left it there.
I didn't leave it there. My things were scattered. When she was kicking me out, my things were scattered, getting kicked into the hallway.
Caption coming up.
When amateurs decide to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out.
A courthouse. The Judy Justice logo appears. In the courtroom, Jennifer and Cardi.
Jennifer Paramon has accused her former friend, Cardi Moran, of breaking her television. Cardi claims Jennifer caused emotional distress after being tricked by Jennifer.
Okay. Did you look for the speaker?
Yeah, I looked everywhere in the hallway.
Do you have her speaker?
There was never a speaker.
Did you see a speaker?
No, I didn't.
Okay, there's no speaker. Now let's talk about your emotional situation. You got to this, I can't even call it intervention.
Trap.
Trap. That's a good word.
There you go.
That's a good word. Thank you. And tell me what happened when you got there.
When I got there, I asked her family member to come downstairs.
Okay. Miss Moran, you walk in the door
Yes.
And there's no question that you were tricked and that this was a trap.
Yes.
That's what it was.
I realized that maybe 1 minute. Okay.
That's what it was. Got in there, and it was an uneasy feeling. You realized that it was a trick to get you there. It was a trap. I want you to tell me what happened when you got inside.
Jennifer starts to walk up to me, like, with her arms open, real slow motion, like, Cardi, I'm sorry. You know, we should talk about this. We're friends. In that same tone. And I'm like, yo, really? You're being fake. I don't really want this. You know, I came here to get what I wanted, and let's go. But Brandon is getting all comfortable. He is disabled, so, you know, all right, fine. He's got to get comfortable. So we start arguing, me and Jennifer, we start arguing.
About what?
About the conversation that me and her had earlier. You know, she said that I should just get over what she said initially for me getting upset.
Okay, so the initial conversation didn't have anything to do with drugs?
We never talked about drugs. When I got to the house, I never had anything to do with them. I was talking to the family member, what I came to get. But once me and her start arguing, I tell Brandon, like, all right, can we go now? Like, are we done here? Like, let's leave. I want to go.
So what happened? When you said to Brandon, let's go, I want to get out of here, what happened?
She squirts me with a water gun. She tells me, oh, I'm gonna squirt you like I squirt the dogs.
Brandon, stand up. Your last name is?
Milner.
I want you to describe this water gun.
To be honest, Judge, I don't remember seeing a water gun.
It's in the video. If you listen to the video, she says it. I'm gonna squirt you
Brandon,
like I squirt
before
the
I
dogs.
look at this again, you were there in the room.
Yes.
I'm going to give you one before I look at the video again. Whether you saw her squirt the water gun or not, did you see a water gun that day?
No, I didn't.
No, okay. So let's play this and let me hear what you're referring to.
Squirt you like I squirt the dog. I said, Jack, are you serious?
Okay, Sarah, you have a much more keen sense of hearing than I do.
I'm going to squirt you like I squirt that dog.
Okay. She's got younger ears than I do. What?
I never squirted her with the
Whether you did or not, are you telling me that
said
Sarah
it.
heard? Okay, so you did squirt it.
But I
you
didn't
say
squirt
it.
her.
I'm going to squirt you like I squirt the dog. Yeah. Okay, but that's not an intervention.
We were arguing at that point. It was already past the
That's because you lured her
conversation,
then.
intervention.
Because you did the wrong thing.
Yeah, it was a horrible plan. It was horrible.
Oh, yeah, they're absolutely right. And it caused a great deal of distress. I want to know how you got out of the apartment.
I was kicked out. I was pushed out. My things were thrown into the hallway.
At what point did that happen? Is that after?
Literally 3 seconds after.
After the TV was broken?
Yes.
You were pushed out the door?
Yes.
Well, that's some really good intervention. How long were you in the house?
A total 6 minutes, maybe.
Where did you go from there?
I got picked up and went home.
Got picked up by whom?
2 hours later by my sister-in-law.
Don't make anything up.
No.
Who picked you up?
My sister-in-law.
Okay.
And my daughter and her boyfriend.
In that 2-hour period,
Yes.
you must have waited somewhere for them.
Yes, I waited in her hallway.
Okay, so you waited. When they came to pick you up, was there any further conversation with her or Brandon? They just picked you up?
Well, between those 2 hours, there was conversations between my daughter and Brandon, my daughter and Jennifer. Everyone was talking.
Well, where was your daughter?
She was home.
So it was on the phone that they were talking?
Yes, and she was pleading with them to give me my stuff back so I could just leave.
The cross complaint, or the countersuit, is seeking $1,800. It's seeking $1,800 not only for the emotional distress that was caused to the defendant, but also for a speaker. They don't have a speaker. How much was the speaker so that I can deduct that?
It was $129.
Okay, so we're really talking about $1,700. Okay, and that's the amount that you want for your emotional distress.
Yes, Your Honor.
For that 6 minutes. I don't blame you. I think it's worth at least that. I think that when amateurs decide for all the wrong reasons to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out. Absolutely. You are holding her there. Yes, just a second. You brought her there under false pretenses. That's what you did. And you had somebody else there as well. And according to you, you wrote it was an intervention. But it wasn't an intervention. It was whether you wanted to
for a 20-year relationship, intervention may be a wrong
Well,
word,
it
but
was a very,
supposed to be
it was a very,
conversation.
very wrong word, and you don't trick somebody to come to your house with something else in mind, even if it's to buy drugs. So I'm awarding you $1,700 on the counterclaim for your emotional distress. Your claim for the broken TV is dismissed. We're done.
This court is adjourned.
I have no thoughts.
I'm happy with her decision, but it's bittersweet because these are my friends.
Just have a conversation about certain situations we were having.
Her intention, I don't think it was to make me stop doing what they all do anyway.
I didn't keep her, that's the thing. She walked in freely, walked out.
That's the betrayal.
Yeah, this is over.
It's just time to go separate ways. You know, I lived and I learned. Those are the people that I grew up with. You know, those turn-up days are over anyway, so.
Sarah.
I think this whole situation was a perfect example of what my dad calls lack of two-step thinking.
Okay.
So we can already agree the intentions were not great. They were just maybe potentially rekindling a friendship, and that's not exactly the person you want leading your intervention, if that's what they wanted to call it. And also, what was your
Florida forerunner.
Court come to order. All rise.
Judge Judy enters.
Have a seat, please.
Kevin approaches.
Hello, Judge.
Thank you.
Case 2160, Canellas versus Terrina.
Thank you.
Judy turns to Susie.
Ms. Canales, is this your son?
Yes, ma'am.
And his name is Chris?
Yes.
Okay. This case is about a truck.
Toyota 4Runner, yes, ma'am.
That was titled in your name, about 21, 22 years old, but was in the possession of your son, Chris.
Yes, ma'am.
And then Chris went to jail.
Yes.
And your great-nephew moved into that house.
Yes, ma'am, correct.
And you moved into that house with your wife, girlfriend?
Fiance.
Fiance.
Yes,
when are you getting married?
so we're waiting on our second daughter in February, so after February.
Okay, well, that's not the way we usually did it 100 years ago in the Stone Age, but I understand that that's the way a lot of people do it these days. Anyway, you moved on to the property. When you moved on to the property, in addition to some other things, there was this truck. When did you give your son the truck? In what year?
It's always been his truck, but I titled it over to him in 2021.
Okay, so you signed over a title to him.
Yes, ma'am.
So it's not your truck anymore. So what are you doing here, suing for it?
He was never able to go and transfer the title or go and register it, so
Because there was not one.
If you say that again, it won't be good for you. We don't shout out here. I run a very organized shop. Got it?
Yes, ma'am.
Okay, so you acknowledge that it's always been his truck. Did you buy it new?
I bought it used for
When?
his graduation in 2005.
What's the value of it? Just
Between 3,000 to 5,000, but that's based on 100,000 miles and good condition. So.
Okay. Chris, stand up, please. On what date did you go to jail?
April 20th, 2022.
How long were you there?
Till July 11th.
What were you there for?
Drug charge?
Is that still pending?
No, ma'am.
When you were arrested or when you were incarcerated, was there an engine in this truck? Be very careful in your answer. Was the truck running?
Yes, ma'am.
How many miles did the truck have on it?
Roughly 220,000.
And you were in the house and you disposed of the truck.
Amongst other things, yes, ma'am.
All we're talking about here is the truck.
Okay.
On what date did you dispose of the truck?
In August, whenever me and Susie made a verbal agreement for me to have ownership of the truck because it was no longer running.
How did you dispose of it?
It was towed away to a junk shop and used for parts.
You have any paperwork?
I have paperwork for the towing.
Great, I'll see the picture and I'll see the towing receipt. That tells you that it wasn't working.
With the new mileage, about 1,900 to 4,000 would be the range. Again, for good condition.
Judy reviews a document.
Okay, and this is an invoice for $75, junked vehicle towed, no keys, no title, doesn't run, wrecked. Kevin, show this to Chris.
Kevin hands the document to Chris.
So that's what you're suing for. You're suing for the value of the truck because it's been junked, so you want $5,000. The truck, at best, if it were running, would be $1,900. According to this, it wasn't running. Now, Mr. Terrina?
Yes, ma'am.
I want you to tell me the conversation you had with your aunt. Her son was now out of jail Because if this happened in August, you got out of jail July 11th.
Yes, ma'am.
Where did you go?
I went to my mother's house.
And that was before the truck was towed.
Yes, Your Honor.
Chris, did your cousin tell you that the truck wasn't running?
No, ma'am.
When did you find out that the truck wasn't running?
I was always assuming that it was running. I did attempt to contact him, and he told me to come pick up the truck. And I told him I was on my way. I believe it was on the July 15th. We have the text messages here.
I'd like to see them.
Chris hands documents to Kevin, who brings them to Judy. She reviews an image of a text message.
Okay, so this all sounds very civilized.
Yes, ma'am.
Okay. Chris, when did it become uncivilized?
It really never became uncivilized. We just, whenever I went to go get it that day, I think something happened and...
I'm not following you.
Okay.
You're all over the place. This all sounds very civilized. He's living in the house now. You were not.
Right.
Some of your stuff was still there.
Correct.
You know each other a long time. He said, some stuff I'll throw away. You said, okay, but the other stuff I've got in the house, come by and pick it up. Okay.
Yes.
At that time, he had to have told you that the truck was not running because he said the truck is at the exact same spot where you parked it.
Right. Well, I just assumed they didn't have the key because a lot of my belongings got thrown away.
Well, they didn't have the key because the tow people said that there was no key.
Right. That's just why I assumed the truck was still in the same spot.
Okay. Now you find out that the truck is not running, right? Because you went there to pick up some of your stuff. Come on.
Yes, ma'am.
Yes, and that was in July because you said you were coming over July 15th.
Yes, ma'am.
So you came to his house where your truck was sitting.
Yes, ma'am.
What did you find out about the truck?
The truck was still in the same spot and it wasn't running.
Same spot.
Same spot.
Did anybody prevent you from taking the truck when you came?
No, ma'am.
Then why didn't you take it?
Just simply for the key. I didn't have the key to turn it on.
Just a second. April, May, June, and July. So the car had not been touched in 4 months. That's what you're telling me, while you were incarcerated. And if you just said to me the car was in the same spot from the time you left now, and there was no key, so you had no idea whether the truck was running or not, right?
Well, I just assumed that it wasn't running because of the key, the no key.
If you were that interested, you would have found out. You would have called a mechanic, they would have come, they would have jump-started the truck, and somebody would have made you a new key. Then you could have taken the truck. He doesn't have to keep your truck on his property.
Well, first of all, my family member said that they were evicted. They had not been evicted.
What evicted? What does that have to do with the truck?
At the time, Your Honor, he, of course, was incarcerated.
No, he wasn't incarcerated. He wasn't incarcerated when you gave him the truck.
No, he was not.
No, I see. I have the dates here that you told me. He wasn't incarcerated. He wasn't incarcerated for a year, and he didn't transfer the title.
I asked my family member if I was able to go into the house and remove all his items and look for the key and the title so I can have the vehicle removed, and everything was thrown out of the house. So when he came to pick it up, it was gone the next day.
Noah grins. Caption coming up.
I have text messages right here saying that she doesn't like being lied to and she's gonna go the court route. I had an officer knock on my door at 8 o'clock in the morning and serve me papers, try to give me a Grand Theft Auto charge and have a felony on my name.
Can I see the text message that she sent to you afterwards?
Later.
He says you didn't make any payments.
I never said I was going to pay him that back.
Well, you told me that you asked him if you could borrow some money. That's what you
A couple
said.
times I asked to borrow money, but the entirety of that, all that, like, I didn't say I was going to pay that back. And he should know he was just being nice.
A courthouse. The Judy Justice logo appears. In the courtroom, Susie, Chris, and Noah.
Susie Canales claims her nephew, Noah Tiarina, owes for the cost of a Toyota 4Runner.
What I'm telling you is he was not prevented from taking the truck the day that he came, which was mid-July. He didn't dispose of the truck until August. That's what this receipt says. I think. Now, this invoice was prepared 2 days ago.
Yes, ma'am.
Well, this doesn't say when they took the truck. How did you get this invoice 2 days ago? It was from August.
I got the invoice because I needed it for evidence, and the towing company that sent me that invoice gave me the incorrect day because they sent it to me on the day that they sent me the receipt.
Doesn't say the date it was towed. Junk vehicle towed. You have any email communication or text communication immediately after the vehicle was towed or before?
With her?
Yes.
I called her the day that it was towed because I have respect for my family member. And I said, I'm towing the truck. It needs to get off of my property today. And she said, mijo, I feel like I should be compensated for the truck. How much do you want for the truck? She said she wanted $500. I told her that I could pay it in monthly increments.
Why would you want to buy a truck that was worthless?
Because I have respect for my family and I hold family very close to me. And if she says that something's not right, I'm gonna make it right. And that's what I tried to do. I failed on that first month of I was supposed to give her $100. I did not pay the first $100. I have text messages right here saying that she doesn't like being lied to and she's gonna go the court route. I had an officer knock on my door at 8 o'clock in the morning and serve me papers, try to give me a grand theft auto charge and have a felony on my name.
Okay. Can I see the text message that she sent to you afterwards?
Noah hands documents to Kevin, who brings them to Judy.
Did you recall, Ms. Canales, having a conversation with your nephew about $500 for the truck?
No, ma'am, I do not.
My witness does.
Shh. How was he supposed to pick up the truck when he just got out of jail the day before you had it towed? And I asked for permission to look for the keys and title, but everything was moved out of the garage. At that time, I was taking my mother to the hospital. But it's okay, I just got to go through the court process. Regardless, you're going to get your money, Aunt Susie. So it's clear that you had a discussion with him about money because he says to you, in response to his statement, so I don't see anything here about $500, but he says, I'm going to get you your money. Well, you didn't say to him, what money are you talking about?
I just told him I was done.
You said, I'm tired of the back and forth, which leads me to believe that that's exactly what happened. Do you have any other documentation of this communication that you had with her? I mean, it's a useless piece of junk of a car anyway.
The only thing I have is a letter of me mailing her the money order. That letter that I mailed her, I have no idea where it is.
Well, I don't know where it is either, but that's a self-serving document. I don't care. But you acknowledge that you told her that you would pay her $500 for the car. She's the registered owner. Is that correct?
Correct.
Judgment for the plaintiff in the amount of $500. I believe you.
Your Honor.
This court is adjourned.
Chris.
He knows he did us wrong, and he knows he's lying right now. This is the only reason why he's acting like that, and that's why the reason my mom is so upset.
It's sad that it had to end that way for a family member because family is something that I hold very close to my heart, and I don't like to see it in that way.
He had free run of all of my belongings, and he ended up selling it.
But at the end of the day, it's my livelihood and my fiance's little livelihood that's at stake.
He knows what he did.
I did not take advantage of my own family. Never.
Yeah, it's tore us up a little bit.
It can't be put back together.
Judy and Sarah.
Troublesome. Tell you some of the troublesome things that I didn't even want to go into with them. He went to jail in April. His mother knew where the car was. She could have gone to get the car. She had 4 months.
Yeah.
Her son went to the house when he got out of jail in July.
And all he had to do was do the same thing the defendant had to do, call a tow truck, have it towed to your house.
Right.
Get an extra key made.
Right. And I thought that he was actually a pretty good nephew.
Yeah, I did too. He didn't have to pay for the car, but he felt for his aunt and the situation that she was in. And
well, he was just trying to be respectful and probably keep the peace.
Exactly.
Between everybody. Well, again, no good deed goes unpunished.
I was just about to say that.
Case 2123, Valenzuela versus Jenkins. All parties, please step forward.
Javon Valenzuela claims his former friend, Darian Jenkins, owes for unpaid loans and bail money from a false arrest.
Mr. Valenzuela, it is your claim that the defendant, who is a friend of yours, owes you for some small loans that you made to him.
Yes.
And then it is your claim that he had you falsely arrested.
Yes.
And you want damages for that. You've known him for a while, according to your complaint. You knew him, you were friendly with him, and then he moved out of state and then moved back. Where did you move to, sir?
To Colorado.
And you moved to Colorado from where?
From Texas.
And in Texas is where you knew the plaintiff?
Yes.
In what year did you move to Colorado?
2019.
And in what year did you move back to Texas?
This year, 2022.
And why did you move back?
Why did I move back?
You moved to Colorado for what?
My family was up there, yeah. And then my family went back to Texas.
Oh, so you moved with your family?
Yeah.
How old are you?
I'm 29.
Did you live with your family in Colorado?
No, we didn't all live together, no.
The reason you say you came back to Texas was because your family came back?
Yeah.
Did you have a job?
Yes, I did.
Where?
I worked from home.
What kind of work?
For a newspaper.
In Colorado?
Yes.
What did you do in Texas?
Whenever I moved back, I was still working from home, but they let me go. I got laid off.
When did you get laid off?
I would say June.
June of this year?
Yes, ma'am.
And what month did you move back to Texas?
Oh, I had already moved back in May.
When you moved back in May, where did you go to live?
I was living in hotels.
But there came a point when you had no money.
It got to a point.
When did it get to a point when you had no money?
Maybe July.
And when did you contact Mr. Valenzuela?
I'd say July.
You didn't contact him in May when you came back?
I just want to say that's a lie.
When did you contact him?
I mean, we talked while I lived in Colorado. You know, we always text each other, so.
Well, when you contacted him in July, what did you say to him?
I couldn't say exactly what I said, but.
Give me the gist of it.
Let me borrow some money, I guess.
Okay. And you needed it for living?
Right.
And what did he say to you?
He did sometimes if I asked him.
Okay. And how much did he give you?
Here and there, maybe 100, maybe 2 every.
No, altogether.
Altogether? Oh, I couldn't say how much altogether.
You couldn't say?
I couldn't say, maybe a few hundred.
Did he give you money for housing?
A couple times he did.
How much?
100 here, 100
Do you have
there.
a record of how much you gave him, sir?
I do.
Okay, because he's already said, and would you read that back to me, Whitney, please, about borrowing?
Said, let me borrow some money.
Right. Okay, let me borrow some money. So tell me how much money you let him borrow.
$1,200.
Show me.
Javon produces documents.
Okay, now tell me what that is that you're giving him, all those papers that you expect me to read.
These are screenshots of every time I sent him money.
Oh, can I see it, please? Okay, get ready, Sarah Rose.
Caption, coming up.
Anybody who came could see that your lip was bloody. You say he fell, must have fallen outside. You don't know how that happened. But if you both are alleging that there was a fight, police would look at you and say, well, he's injured. They wouldn't have arrested you unless you had a warrant, right?
Javon shakes his head. A courthouse. The Judy Justice logo appears. In the courtroom, Javon and Darian.
Javon Valenzuela is suing his former friend, Darian Jenkins, for unpaid loans and damages from an assault.
So every time you gave him money...
He agreed to pay me back.
No, he's already told me that he called you and asked if he could borrow some money, and you said yes, and he said, I don't know how much it was. So if he doesn't know how much it was, you have screenshots of it, and Sarah is going to add them all up. Okay.
Judy hands documents to Sarah.
Of all the money that you said that you borrowed from him, how much did you pay back?
120.
Good guess. Did he give you back $120?
No.
Did he give you back anything?
No.
Nothing ever?
No.
Okay. So while Sarah is adding that up, there came a point when you left the hotel. Is that right?
Yes.
And Mr. Valenzuela probably got tired of giving you money and it said that you could stay in a spare room in his house.
For the most part, yes.
And you moved in August of 2022, the end of August.
Yes.
And then in September, you had a fight. I don't care what the fight was about. It became physical?
He was physical, yes.
No, I wasn't, Your Honor. No,
Okay.
I wasn't.
Let's say you had an argument that spilled out into the street, because this becomes very important, because there's the other charge is false arrest. And it was a false arrest, you claim, based on his statement to the police that you assaulted him.
Right.
Right. He says, yes, you had an argument, but you weren't arrested on his allegation that you assaulted him, but you were arrested and held on an outstanding warrant. When the police responded, they found that there was an outstanding warrant. So now I want you to tell me, in September of 2022, did you have an outstanding warrant? That's either a yes or a no.
Well, it was on a payment plan.
I don't care what it was. Did you have an outstanding warrant?
Yes.
And the outstanding warrant was for a what?
Traffic tickets.
What kind of traffic ticket?
I think I was speeding, and I didn't have my license either.
So speeding, driving without a license. What else? You have insurance?
I think it was insurance.
Not think. Speeding, driving without a license, and no insurance.
And no tags.
And no tags. And for that, you got fined.
Yes.
And you didn't pay the fine.
I was paying it.
Well, there wasn't a warrant outstanding because you were cooperating and paying the fines.
The county that I'm in, they said, the police officer said, it doesn't matter if you're on a payment plan. They'll arrest you if they want to.
Mr. Valenzuela, did you miss payments on your fine?
Yes.
Perfect. And so when the police responded to this kerfuffle that was out in the street, when they ran both your names, your name came up with an active warrant.
Yes.
Well, that's easy. So that you were arrested on the outstanding warrant.
I would have never been arrested, though, if he wouldn't have acted.
If he didn't call the police.
No, he didn't call the police.
Who did?
My neighbor did, because the way he was acting.
So your neighbor called the police, but for the outstanding warrant, I don't know whether the police would have taken you into custody. You had an injured lip. They could see that your lip was bloody. You say he fell, must have fallen outside. You don't know how that happened. It's really not relevant to this case. But if I were the police and I showed up, you didn't have any visible injuries, right? No. You had a busted lip. If you both are alleging that there was a fight, police would look at you and say, well, he's injured. He's got a busted lip, got to sew it up. They wouldn't have arrested you unless you had a warrant, right?
Right.
Good. So that's not his fault that you had a warrant. It's not his fault.
I have that total. It's $2,727.56, and that's including some direct payments to Motel 6s and other housing accommodations.
Includes that?
Yes, in addition to direct payments to the defendant.
Great. He says you didn't make any payments. $27.27.
I mean, there's no way he expected me to pay. I never said I was going to pay him that back.
Well, you told me that you asked him if you could borrow some money. That's what you said.
A couple times I asked to borrow money, but the entirety of that, all that, like, I didn't say I was going to pay that back. And he should know he was just being nice.
He was being nice.
Sometimes he offered.
Not anymore.
Yeah, not anymore.
You have a job now?
Yes.
Okay, great. 27-27. Judgment for the plaintiff. We're finished. Thank you.
This court is adjourned.
Darian.
I think he was just mad overall, so he just picked something to get me back with.
Just like he said, he thought I was being nice. Why would you say you're going to pay me back, but then not pay me back?
He was screaming, yeah, he was screaming, yeah, just screaming, cussing, like, embarrassing.
He was acting crazy, and because he was acting crazy, he woke up the whole neighborhood.
Well, he was drunk going crazy outside, running around the apartment complex, so she called the cops on him.
That's what made my neighbor call the cops, and that's why they came.
Oh, no, there's no friendship. It's gone. Yeah.
Don't have friends like that, but also don't bite the hand that feeds you. Nothing comes good out of it, so.
Sarah.
Just something funny from the receipts that I was looking at. Some of them say, you know, the price really big on Venmo or Cash App, and then it just says completed at the bottom. On some of them, though, you could see heart emojis that the defendant sent thanking him.
scales for the cost of a car.
Court come to order. All rise.
Judge Judy.
Have a seat, please.
Kevin approaches the bench.
Hello, Judge. Case 2130, Laws versus Law, scales.
Thank you.
You're welcome.
Ms. Laws, this young woman is your niece.
Yes.
And this young lady is the ward of your niece.
Yes.
You have guardianship over her. Is she related to you?
No, she's related to my wife.
Okay. But you have guardianship.
We both do.
How old are you?
I'm 21.
You had an automobile.
Yes.
It was an automobile that you allowed your niece to use, and it was at her house.
Yes.
That was in September of 2020. Her car was in the shop, whatever.
Mm-hmm.
Anyway, your niece went out of town for a while?
Yes.
Do you remember what date that was?
October 17th of 2020.
And prior to your going out of town, had Miss Scales ever driven the car?
No.
Had you ever given her permission to drive the car?
No.
Now, Miss Scales, there did come a time in October of 2020 that you took the car.
Yes.
Tell me how you managed to get a hold of the car.
So the keys, we have a key hook in the front of our house, and I just used the keys there.
Did you ask anyone?
No.
Tell me why.
I had a scare that I was afraid to do by myself.
What kind of scare?
A pregnancy scare.
Okay. So you took the car to go where?
To who I was dating at the time.
What time of the day did you take the car?
Between the times of 4 and 6 p.m.
And at what time did you have an accident with the car?
I would say between 7 and 8 p.m.
Had you already seen the boyfriend?
No.
Where were you between 7 and 8? Where were you
Driving.
going? Driving to who?
To the boyfriend.
Oh, so it takes a while to get there?
Yes.
How long?
About an hour.
In any event, you had an accident.
Yes.
The car was totaled. You had insurance?
Yes.
And had you told your niece that you had insurance on the car?
Yes.
Okay, because she says that you had told her you had insurance on the car and you had a loan on the car. There was a note.
That's correct.
So when she borrowed the car, she knew it was insured. Did you also tell her that you had the gap insurance?
Yes.
And what year, make, and model of car was it?
A 2015 Mitsubishi Mirage.
Did you buy it new or used?
Brand new.
And how long was the loan on the car?
6 or 7 years. I think it was 6.
So by 2020, you had paid up most of the car.
Yes.
What was the balance left on the car?
I'm not exactly sure the exact balance that was left on the car.
Okay. How much did you pay for the car?
I paid $17,000. That's what it was financed at, so that's not with the finance charges.
Okay, so you paid $17,000. How much of a down payment did you put down?
I didn't put any money down on it.
So in 5 years between 2015 and 2017, you paid off about 80% of the car.
Yes.
What's the car worth now?
Based on 75,000 miles in good condition, I'm seeing between 5,500 and 7,500.
Okay. Now, after the accident, you put in a claim through your insurance.
Yes.
And your insurance covered how much?
The insurance paid out $7,379.
They wrote a check to the bank?
Yes, ma'am.
And can I see the paperwork on that, please?
Yes, ma'am.
Because what you're suing for now is another $8,496.
Mm-hmm.
Jennifer hands a document to Kevin, who brings it to Judy.
Okay, so your insurance also paid on the other car that you had the accident with. You had an accident with a Ford Focus?
Yes.
Okay, so they paid $2,900 on that, and they paid you $7,379.
Yes, ma'am.
And show me what the note balance was on the car at the time that they paid this out, which would have been sometime in 2020 or maybe 21.
You want the balance after they paid out or before they paid out?
Both.
Okay. This is after they paid out.
And before.
I don't have a copy of what it was owed on before the accident.
Oh, I need a whole payout because what your niece says is that they paid you the value of the car, which clearly it was the value of the car, because the value of the car, according to Sarah, is between $5,000 and $7,000. They paid you $73.79, which clearly covered a substantial part of your note. Mm-hmm. What the defendant is saying is that during COVID, for financial reasons, you requested that the payments be put on hold.
Right.
And that you not make any payments on the car, and that the interest would continue to accrue.
Right.
And that's not her fault. You asked to have the payments put off, but you drove the car. You had the benefit of driving the car all during COVID.
Right.
And she shouldn't be penalized. The insurance company paid out what the car was worth. These additional charges are because you put off making the payments during COVID, and it also accrued that interest. That's your defense. Am I right?
Yes.
That I have to see.
Okay.
I don't want to hear it. I want to see it.
The paper that you have there, that's from, it shows that a payment was made on that car on September 4th, 2020, and that was the last payment that was made. So if there were no payments being made during that time that she had the car, it was.
That's not what I'm asking you. I'm asking you, when COVID started, did you put the payments on hold?
I did, because I was no longer working, so they gave me the option to delay my payment, which means they tack them on to the end.
And I understand that, but you were driving the car. You were driving the car. She's not going to pay for that.
She had the car from the beginning of September, and she was only supposed to have it for 3 days when her car got fixed.
It doesn't matter. First of all, you didn't bring me the documentation that I need. You didn't bring me what was actually owed on the car, and what was owed on the car, and how much was owed as a result of your deferring payments and interest.
When I did the stop payments on the car, it was before she even borrowed it.
Well, that may be, madam, but if what you're telling me is you started to pay again, you still drove the car when you deferred payments.
Yes, I did.
Yeah, well, that's not her responsibility.
But the balance that's left on the car, they paid what the value of the car was. They said that they don't pay finance charges. So there was a balance of 37.
Well, the finance charges were finance charges that accrued, and you don't have the paperwork for me here.
$3,700 worth of finance charge for 2 months?
No, that's not for 2 months. I don't know what the finance charges were for. It doesn't say that. You don't have the paperwork here. You don't have the right paperwork. So you have to understand something. What you're suing her for is $8,496. First of all, the car is only worth $5,000. You got $7,300 that the insurance company paid directly to the lender. And I don't have what you owed here before the accident. I don't have that. And the payments that you deferred, if you deferred payments prior to that time, that's your responsibility.
But I only deferred payments for 3 months. That's not going to
Just a
amount
second.
to $3,700.
I have no idea. You should have brought the paperwork. This is not that paperwork.
So I'm out of a whole car. Like, I've invested almost $10,000 into this car. I let her use the car, and
that's what your insurance for.
And now I'm just not out only the $3,700. Now it's been late charges and other charges on that, and now it's $6,000 that's on my credit.
You deferred the payments. I can't tell how many months you deferred the payments. You said maybe I deferred 3 payments. I don't know. You didn't bring me the paperwork.
I deferred.
You can't tell me.
Caption coming up.
If she would have never had the car, then I would have been responsible totally to pay all of that amount. It's cost me more than just this amount that's still on my credit.
She didn't do anything wrong so far. I mean, you have a 21-year-old girl who shouldn't have taken the car keys without permission.
And later today,
you write to her that you saw her take some stuff, and you say to her, so don't tell me you don't steal from me. Friends don't steal from friends, so I won't burn you for what I borrowed. You should think twice before you steal from, because I could say, I'm not giving you nothing.
A woman shakes her head. A courthouse. The Judy Justice logo appears. In the courtroom, Jennifer, Janelle, and Ari.
Jennifer Laws claims her niece, Janelle Laws, and her stepdaughter, Ari Scales, owe the balance on her car after Ari totaled it in an accident.
She says you deferred the payments. That was the reason for these overages, which I can understand, because otherwise the insurance company, and if you had gap insurance, which you say you did, would have paid any gap between the loan.
My gap insurance was only until a certain amount of time, and then after that, the gap insurance only pays a certain amount.
I don't know any of that. What I need from you, you didn't bring. You brought only what was necessary to put forth your position. I need what was owed on the car and for past due payments with accrued interest and for current payments. And you don't have that. So far, all I know is you had full insurance on this car and the full insurance was paid. And if there was a reason that the insurance company, for some reason, didn't pay an amount of money, I don't have an explanation of that here in what you gave me, except the explanation that she offers, which was during COVID, you deferred your payments and the interest was accruing, and that the insurance company was not going to pay because that was done prior to October.
That's not
2020.
That's not true. I deferred 1 or 2 payments.
Well, 2 minutes ago, was that 3 payments?
Because, ma'am, I'm sorry. Let me just explain that. During this time, April 2020, I lost my mother to COVID. So I had 2 cars. I had the pink car and I had the car that I gave to my mom, which is a black car, which was also in my name that I was responsible for. The car that I put the deferred payments on was the Kia Optima. That's the one that I put the deferred payments on. This car, I had a couple late payments, but I never stopped paying that car note.
I can't tell you. You don't have the paperwork. All that I can tell you is the insurance company paid everything that they were supposed to pay, including the gap insurance for this accident. So I can't help you.
Did not pay.
Listen to me. I'm not going to repeat myself. This doesn't tell me how much you owed prior to the accident and what it was for. And if it shows that all you owed currently prior to the accident, it had to show that that was $73.79 and it included the gap insurance. You may have had old finance fees that had nothing to do with her.
The gap insurance never paid.
I can't help you, madam. You don't have the right paperwork.
If she would have never had the car, then I would have been responsible totally to pay all of that amount. But because I don't have a car, it disrupted my life. It's cost me more than just this amount that's still on my credit.
She didn't do anything wrong so far. I mean, you had a 21-year-old girl who shouldn't have taken the car keys without permission. But the car was there, and it was there with your permission, and there's no question that the accident was her fault.
I have been asking her to return my car.
If you have the proof, the only thing I want you to show me is a document from your lender which says how much was owed at the time of the accident and for what. Do you have that?
I don't, because I didn't think that I needed it.
Okay, well, then I can't help you. Today's a court day. This is the day you have.
I have a ton of evidence here.
Madam, you don't have the evidence that I need. Your request for $9,000 for a $5,000 car in which you've already been paid $7,300 is ridiculous. So all I have to see is how much was deferred and the interest on the accrued that you deferred while you were using the car before she had it for this 5 or 6 weeks that she had it in September. If you have that, I'll look at it. If you don't have it, I'm not interested. Do you have
the paperwork that you have?
Well, then I'm going to give it back to you, and you're going to show me where it shows here in October of 2020 how much you owed on the car and how much were past payments and finance charges based on the last payments.
Jennifer reviews the documents.
You understand what you gave me? If I could make this as simple as possible for you, if you never loaned her the car, if you had the car for that 5-week period and you had an accident with the car during that 5-week period, you would be in the exact same position you are now. The company would have paid off what they paid and would not have paid off what you still owed them because you deferred payments. It doesn't matter who was driving the car.
And I do understand
that. Okay, good.
And I'm glad you understand.
I'm glad you understand it.
My car.
I'm glad you understand that. Your case is dismissed. We're done.
This court is adjourned.
Outside the courtroom, Jennifer, then Ari and Janelle.
She needed to borrow my car.
It was just a bad accident. It was just me, young, got into an accident.
So I thought that I was helping her. You know, so when this balance is due, I'm the one that's out.
The car hit me and ran the light and it hit me.
You know, I'm the one that suffered. I'm the one that got to pay all of that money.
I'm fine.
So I don't think that that was fair at all.
Judy and Sarah.
So for a period of time, let's say 6 or 7 months, her numbers kept changing. First it was 3 months she didn't pay, and then it was 1 or 2 months that she didn't say, and she may have been late a little bit. Well, the insurance company's not going to give you credit for that. And it didn't look to me, based on the papers, that there was any animus between the parties until
just right now.
Today. and then maybe she should be angry with me and not at them. They all know each other and get along with each other. So that the amount of money she has to pay is the amount of money she should have paid while she was driving the car but chose to defer.
And I think that that's a good lesson about deferring payments, especially now with COVID and everything. I know people my age, 25, around there, have been deferring payments, whether it be for car notes or for interest on your loans, things like that, that sometimes she didn't even realize that this was all accruing under the surface. So you think that by deferring, if you don't read the fine print, that could be a good lesson that
yeah,
if
she said she had a lot of other things going on in her life, but that...
And again, it was an accident. You don't call it an on purpose. So.
Right.
Case 2133, Morrissey versus Comer. All parties, please come forward.
Tabitha Morrissey is suing her former friend, Tina Comer, for an unpaid loan and personal belongings.
Ms. Morrissey, you have a lot of claims here against the defendant for a personal loan and the value of personal belongings.
Yes, Your Honor.
Okay. She was a friend of yours. You used to go gambling together, Ms. Morrissey?
Yes, we did.
How many times a week did you go gambling?
Probably once or twice a week.
And did you go just the two of you?
Yes.
And over what period of time?
Over...
A year, 2, 3?
Probably a year.
There was a time when you went, and according to you, Miss Comer didn't have any money. And so you agreed to advance her money. And she says, actually, you agreed to advance her money. And the agreement was if you won, she would pay you back with her winnings, whatever it was. Whatever it was. How much money did you give her to gamble?
I loaned her $230 with the agreement that she would pay me an extra $200 because she was going to get her mother's inheritance.
Okay. On what date?
April 28, 2022.
Okay. And you went gambling with her?
No. She came by and we were going to go meet at the casino, but I didn't really want to do it because I have a boyfriend that doesn't
Just a second. I don't need a whole story.
Okay. All right. Sorry. So she went to the casino without me, and then she came by my house after that and told me that she spent her boyfriend's money at the casino, and so that she was supposed to use it at the store. And so I gave her the money to cover that, and that's when we made that agreement.
You gave her the money to cover that because she asked you for it?
Yes.
And she agreed to pay you back?
Yes.
Okay.
Caption, coming up.
February, did you go to the casino and lose some of your boyfriend's money?
No.
Did you go to her house and tell her that you lost some of your boyfriend?
It wasn't in February.
What month?
It was probably April.
I don't care what month it was. Did you tell her you lost your boyfriend's money at the casino?
A courthouse. The Judy Justice logo appears. In the courtroom, Tabitha and Tina.
Tabitha Morrissey claims her former friend, Tina Comer, owes for an unpaid loan and personal belongings.
Judy.
Go.
No, it was in February.
Okay, February.
I won a jackpot.
Just a second. February, did you go to the casino and lose some of your boyfriend's money?
No.
Okay. Did you go to her house and tell her that you lost some of your boyfriend?
It wasn't in February.
What month?
It was probably April.
I don't care what month it was. Did you tell her you lost your boyfriend's money at the casino?
$30 of it.
Judy glares at Tina.
Okay. But in February, I won a jackpot, and I didn't have my license with me because I lost my wallet. And they told me I had to come back with my license to get it.
I don't want to hear you.
Sorry.
So I asked Tabitha if she would take me back up to get my jackpot money, and I would pay her the money that I owe her, plus give her $60 for gas. And that's when I paid her the money back. And then her boyfriend also, there's some guy that she brought up there with us, asked if he can borrow some money because he said Tabitha said she'll pay me back. So I gave him $100 too.
When you came back and told her that you had lost some of your boyfriend's money, according to you, it was $30, not $230.
It was $30. I already paid her the $2-something when she took me to Cass Creek in February.
Oh, that was before.
Yeah, so I didn't owe her no money. But I paid her back in February, the money that I did owe her. I got proof of it too.
I'd like to see it.
And I got proof that, okay.
Take it out. I'll see whatever proof you have over this loan.
Okay, yes.
Tabitha and Tina both search through piles of documents.
Come on, let's go.
Okay, well, here's where I won the money.
Proof. I also got proof of her saying that when she still owed me the money back in May. I got proof of that too.
Casino check. I'm not interested in this.
That's when I won the money.
I don't care.
And the other one shows when I had to go back and pick it up.
I don't care about that either.
And then...
Shh. April 28th. I can loan you some. That's in April.
Yeah, I said April 28th.
So that's when she asks for some money.
Yes.
And that was the $230?
Yes.
I'd like to see what you have.
This is.
That's April. That's not February.
No. That's in June when she told me how
She's only gone cash
what
wise.
she owed me in cash wise.
Okay, so on June 11th, Ms. Comer, you write to her that you saw her take some stuff.
Yes.
Some beads, or friends took beads that belonged to you, and you say to her, so don't tell me you don't steal from me, friends don't steal from friends, so I won't burn you for what I borrowed, which is $230. But I decided I will not give you the other $200. So I'm just not going to give you the extra. That's what it's going to cost you for stealing from me. You should think twice before you steal from, because I could say, I'm not giving you nothing, so I'm only taking back what I was going to give you. We had to sign some more papers, so I should get it any day, and I will text you when I get it. I'm also missing a half box of sunglasses, and that girl is going to get it. She lied saying the hair clippers were hers. I don't care about all that. Okay, I'm going to deal with this loan of $230. And it's clear from your statement, Ms. Comer, although it's usurious interest, and I'm not going to grant you that other $200 because it's outrageous. She's giving you 100% interest on the $230, but you are entitled to your $230 back.
But
okay, because she acknowledges, just a second, she acknowledges the debt on June 11th.
Mm-hmm.
Now, what about the personal belongings that you say? And don't give me a lot of nonsense. I'm not listening to a lot of nonsense.
Okay, yes. She came to me and said she wanted to do a yard sale, so we were going to do it in May.
Okay, you were supposed to do a yard sale.
Yes.
It worked for a week. It didn't work the next week. What items do you say she has of yours?
She has jewelry of mine.
I'm not listening to jewelry. Show me the insurance receipts for jewelry. Come on. Let's go. What does she have of yours?
I can show you the pictures of her yard sale that does have my stuff in it.
Well, what did she end up with your stuff for? You were there at the yard sale.
I didn't have a car, so she came and picked me up and took me to my storage to go get my yard sale stuff to take over to her house to do it in the yard sale. She was supposed to contact me and come get me when she was getting ready to do the yard sale. I stayed the night at her house, and we were setting up all night long because it was a really big yard sale. It was more like a flea market type thing. And she never contacted me after dropping me back off at home, and she said that my box of jewelry fell out of my stuff when she was loading it up because she fell. So when she got home that night after dropping me off, she said it was in the driveway.
You have that in text
That was my
message?
personal belongings.
You have it?
Yes.
I'd like
yes,
to
I
see
do.
it.
Okay, hold on.
Thank you.
Tabitha hands a document to Kevin, who brings it to Judy. She reviews a text message.
So this looks like a lot of cheap plastic crystals.
No, my wedding ring was in that box. I had my box of jewelry with me to go through when I stayed the night at her house, and I was taking out the other jewelry, and the box that was coming with me home, she was loading it up, and she said it fell out of her car. So I don't see how it fell out, but she said it did. So when she got there that night, she said she'd seen it in her driveway. So, I mean, that had my wedding ring in it. And I was in the middle of getting the divorce, but it still means something to me.
$230. Judgment for the plaintiff. We're done here. Thank you.
This court is adjourned.
Outside the courtroom, Tina, then Tabitha.
Everything she said was a lie about the money, about all her stuff. Everything was a lie.
Because she just doesn't want to pay me my money.
She could just